supposed to be held in person, not Zoom.
I'm
Ms.
sorry,
Danny?
you said it's supposed to be in person?
Yep. All PCCs now at the 27th District Court for the past 2 months have been strictly in person.
Okay, so when they gave it to me, they said it was going to be via Zoom because I am scheduled for an exam this morning. So can I do this one by Zoom today? The PCC?
Good morning, Miss Fanning. This is Judge DiSanto. When were you given the assignment?
I would have, well, I did my visit with my client last week, so it would have been
Okay.
maybe a day before that.
Okay, so I don't know if somebody gave you misinformation because they also sent out an email to the attorneys indicating that the 27 district courts PCCs are now in person. The
Okay.
only exception we do have is when somebody's spot appointed. We do make an exception for that.
Okay.
What time is your exam?
It's supposed to be at 9:30. So I
All
can
right,
come after, well,
Can you please turn on your, counsel, please turn on your camera.
Okay. Not a problem. Yes.
Oh, there we go. Okay, you're not driving, are you?
No, I'm
Okay.
stationary.
Okay, thank you. Okay. All right, where is your exam at, counsel?
It's in Warren.
Okay, and so that's at 9:30, and then you said you can be here after that?
I can definitely try to make my way there. Yes.
Okay.
Okay.
Have you spoken to your client? Is he in Wayne County Jail?
He is in the Wayne County Jail, and I have spoken with him. Yes.
Okay, all right, we will make an exception and we'll allow you to appear via Zoom, counsel.
Okay.
But please just keep in mind that we are not doing Zoom by way of
PCCs.
I'm sorry, yes, we're not doing PCCs by way of Zoom anymore, yes. Mhm.
Okay. Not a problem. So if I can maybe just get a breakout room with the prosecutor, that would probably be very helpful.
Okay,
Thank you.
we will do that, and then we will see where Wayne County Jail is at.
Okay. I appreciate that. Thank you so much.
You're welcome.
Okay.
Sorry, the cooler's broken.
Mr. Holmes, good morning. Your attorney is here in person, so we'll put the two of you in a breakout room if you need that in just a short bit, okay?
Thank you so much, Your Honor.
You're welcome. Are you in treatment right now, sir?
Yes, ma'am, I am, Your Honor.
Very good. Okay, thank you.
Thank you.
Good morning, Wayne County Jail.
Good morning.
How are you?
You're doing well, and yourself?
Oh, pretty good, pretty good. And who do you have there today?
We have three for you today. We have Nadine Coop. We have Ronald McClure. And we have Jarrett Lewis.
Okay, perfect. Are you able to tell us if Mr. Campbell, Elijah Campbell, is on his way to the court here,
I can
please?
check.
Okay, thank you.
What's his the name again? Make sure I get it.
Elijah, Elijah. Okay, are you able to turn down the volume on there? Because there's a lot of reverberation in that
There we go.
spot.
Does that work?
Okay, thank you. Not really. Okay, it's a little bit better. Elijah, Elijah.
Yep.
Campbell, Campbell.
Okay.
He's
I will
supposed to be here
check, Your
for
Honor.
preliminary examination in person.
Okay.
He also has two PCCs also. I just want to make sure that he's being sent here for his in custody exam.
Okay. Let me check for you.
All right, thank you.
Is there any one of these individuals you would like to see first?
McClure, if we can have McClure on the screen because his attorney's on screen. Is she still on there?
Yeah, she's in the break.
Okay, yes, and she has an exam that she has to pop into, so if we can get Mr. McClure on screen first, that'd be great.
Okay, no problem.
Thank you.
The county just dropped Mr. Campbell.
Oh, deputy? Okay, great, he was gonna check on that.
Oh, that's taking the other one on.
Okay.
What's that?
Okay.
Mr. Lewis.
Lewis, yeah.
45.
Campbell's not there, he's in person now. Deputy?
Okay. Yeah, right here.
Deputy, we just got word that Mr. Campbell was dropped off here at the court.
Okay.
Thank you so
We're
much.
gonna put
for your help.
another camera on as well, for you, so you'll have this. So this is Mr. McClure now.
Okay, very good, thank you. Mr. McClure, we're gonna put you in a breakout room with your attorney. Okay, and then. Okay, so, Ms. Dunn, do you have to speak to, any of your clients that are in custody? No, okay. So, let's see, what's that?
I said I'd already been to the jail.
Okay, thank you.
Are you representing Mr. Campbell?
Yes,
Okay. Do
so I'll see him here.
you want to talk to, well, they're still booking him in. Do you want to talk to him?
I can wait until after we handle a couple.
Okay.
things.
Is this Ms. Dunn? Good morning, are you Ms. Dunn?
No,
I mean, Ms. Coop?
Yeah.
Okay, very good. All right, so Ally, let me know if we're ready to go. Okay,
Now I can hear you. Sorry.
all right, let's go on the record in the matter of the state of Michigan versus Nadine Coop, 26944. Counsel, your appearance, please.
Thank you. Christina Dunn from the Neighborhood Defender Service for Ms. Coop, P 45490.
All right, thank you. And Ms. Coop, your name for the record, please.
Nadine Coop.
All right, thank you. Today is the date scheduled for the probable cause conference in this matter. And counsel?
We are setting this case for an exam.
Okay, and so your client was arraigned on July 15th, so within the 21 days is going to put us to the August 5th, which is not a date that we do those, nor is it a date that we have a docket. That's the conference for district judges, so it looks like it'll be the 30th. Unless your client's going to waive time and we can put it on for August 13th.
Let me just double check. Calendar.
Okay,
So the 30th of July. is
Yes.
available. We'll take that date. What time?
well, I think at this point it doesn't really matter. I think we have like 7 exams scheduled that day, so it'll kind of, but let you know what time.
Okay. I guess I would prefer afternoon to morning.
Okay, well, it's gonna go with what our docket can accommodate.
Do 1:30.
Very good.
All right, 1:30 PM and any witness and exhibit list by July 27th.
And I will visit you, Ms. Coop, at the jail, and we'll discuss.
Council, I'm not done.
Also,
Not done. And the court's going to order any bond and conditions are continued. And anything else, council?
I was just gonna say, Ms. Coop, I'll see you in person at the jail, talk about this privately, okay? We have an exam date, it's the 30th of July.
Okay.
Did you hear all that, Ms. Coop?
I did not.
Oh,
I didn't
I'm sorry.
understand.
Your attorney indicated she's going to come and visit you at the jail so she can speak to you about this before your exam, which is scheduled next Thursday, and that's in person here at the court.
Okay, now I understand.
Very good. Okay. All right, bond and conditions are continued. Have a good day, ma'am. Thank you.
Thank
All
you.
right, let's go off the record for a moment. Do you represent Mr. Holmes, counsel?
Do,
Okay.
I can tell you that Mr. Holmes, I went to the Wayne County Jail, he has a very high bond, so he hasn't been released, but they told me he's in custody somewhere else.
No, he's in treatment, is where he's at. He's in treatment.
They just didn't know.
So if you'd like to zoom in, I can put you in a breakout room with him. He's on Zoom.
He's on, yes.
Yes.
I'll have to do that.
Okay, perfect.
And can the court just tell me the Zoom pass?
656, there's not a password, 656-647-7075.
656-647-7075.
Yes.
Did it?
Okay. And that's a number that's permanently ingrained in my brain, like my childhood telephone number. All right, so let's go. Mr. Holmes, we're gonna have you go into a breakout room and then, your attorney's going to log in, that way you can speak with your attorney.
Thank you, Your Honor.
You're welcome. And Ms. Coop, you're all set. So just, if you want to let the deputy know that they can put the next person in there, okay?
Great, just knock it on the door.
Yes,
Okay, thank you.
thank you. Okay, Ms. Fanning, are you ready to go on your matter? Ms. Fanning? Ms. Fanning, are you ready to go on your matter, or do you need to speak to the prosecuting attorney?
I am, Your Honor. It's going to be a waiver.
Okay, did you already speak to Mr. Mohammed?
I have not spoken with Mr. Mohammed. I thought that they were going to put me in with him, but instead they put me in with my client.
Okay, so we will put you in with Mr. Mohammed so that we can have that,
Okay.
that conversation and we can get the file.
Thank you.
You're welcome. All right. And, are you Mr. Lewis?
Yes, ma'am.
Okay,
Yes,
very good. All right, we're just waiting for your attorney to log in. Or not log in, but to arrive. Okay. Is this the one that's, for exam pieces? All right, so.
I haven't even discussed nothing with him.
Please. Okay, so let's go on the record in the matter of Michelle Yenna, 221318, and the city of Wyandotte versus Michelle Yenna, 26443. Counsel, your appearance, please.
Your Honor, good morning, Richard T. Serrano, P. 3828, appearing on behalf of my client, appears to my right. I appears on my DC counsel today, Your Honor, for the cases that the court has stated.
Thank you. And ma'am, your name for the record, please.
Michelle Yenna.
All right. And so, ma'am, how are you doing?
Good.
You look better.
Yes.
How are you feeling?
Good. Great.
Good. All right, so today's the date scheduled for probation, well, sentencing on the probation violation. Your client previously pled guilty on April 22nd of 26 to the probation violation for the matter she was on probation for from 2022. Then your client also pled guilty to possession of controlled substance under 155.001 if eligible. And so that sentencing is today as well. And ma'am, you've completed your treatment, correct?
I'm still in the second phase. I'll graduate on the 22nd of September.
Okay, I'm sorry, you completed your inpatient.
Yes, I did the inpatient.
Portion.
Now I'm in the recovery house.
All right, very good. And you're still in the recovery house?
Yes. And I'm supposed to graduate the 22nd
Very
of
good,
September.
very good. Okay, and so why did you miss a couple of your interview dates with probation?
It was like a communication thing. And I didn't have the paperwork myself. So now, and then Officer Gillespie just came like 2 days, I think it was yesterday, 2 days ago, and changed my tether, because I was having issues with the tether. And then he told me that I had a warrant, that I was supposed to be in court.
Okay,
So
Officer Gillespie?
Gillespie, he's the tether agent from Detroit.
Oh, Gillespie?
Gillespie.
Oh, okay,
Gillespie.
okay,
Yeah.
all right.
He told you had a warrant from this court?
Yeah, he said this one.
Right.
Well, yes, because she did not appear
Yeah.
on June 17th.
I understand.
Right, for sentencing. Okay, and so, counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor, we've talked about it. As she stated, she's doing well at your house. They brought her today to take her back. He's in the second phase, finishing that, but we're about to go to the third phase. She wants to remain in the program, of course. Your Honor, she's told me exactly what she's indicated to you, that she's feeling much better. She does have a prescription for Suboxone, which she takes once a month via injection. The only thing she has pending, Your Honor, before this court that she tells me.
No, there's a warrant from 2021 in 36th District Court
Oh,
that you have to take care of.
okay.
It appears to be.
And what year?
2021. It's a traffic offense for no insurance.
That's what she just told me, yeah.
Yes,
An A.
I'm sorry.
It's an A.
Well, but that's a misdemeanor, so it requires a court appearance unless somehow they go to under an ordinance that doesn't require that. So just confirm that with them because it's still showing up
Okay, so I gotta go to that court to make it.
or contact the court, but yes, one way or the other.
Yes, Your Honor, we would hope that the court would consider her plea under 155.001, of course, and Your Honor, the time lapse, the times that she's missed court, she just told me flat out, I was on drugs, determining other choice. Obviously, she could not do that alone. She's had help, it's working. I don't see any reason to disturb what's working for her. I understand there has to be some type of punitive measures. When she gets out, she hopes to get back into society. They're going to help her find housing and she can get back to work. But then she's pretty much homeless, separated, supposed to minor children. And with that, Your Honor, we leave it in the court's discretion.
But wait a minute. Okay, so this is why I'm slightly confused because we don't have a PSI to do the sentencing for.
Well, I thought Michelle sent me only a one paragraph recommending time served.
Well, yes, see, I don't have information about your client's criminal history since 2023.
Because you didn't appear for
Did it-
PSIs.
Correct, to determine whether or not your client's eligible under 155.001.
I understand. Your Honor, if we have
So
immediate probation.
let's do, well, she can meet with probation, but we're going to have to adjourn the sentencing is what we're going to have to do. Because their schedule is such that they can't meet with her and whip up a report right away. That takes a little bit of
That makes
time.
sense, Your Honor. Yeah, I thought maybe the paragraph would suffice for that, but I see the court's reasoning that to be qualified, you have to look further than just a one paragraph report.
Okay, so you have to stay to be interviewed for your PSI. Since you're in person, we'll just have you do that today.
Okay.
And so if you test right now, ma'am, what's in your system?
Just 7K.
That's prescribed.
That's it. Yep.
Okay.
It's about the same things.
Correct, yes. All right, the court's going to order bond and conditions are continued. And honestly, ma'am, this is likely going to be either the end of August or beginning of September for
Okay.
your sentencing date, okay?
Okay.
And then I will adjourn your sentencing on your on the 221318. Okay, I'm glad to see you're doing better, ma'am.
Thank you.
You look better. You look like you're doing better.
Thank you.
That was the first thing I noticed.
Report preparation then.
Yes, yes.
All right, then I'll see you next week.
Okay.
Okay, thank you. Don't leave without going to probation, ma'am, okay?
Yeah, I'm going.
All right, thank you. All right, is that the one from the clerk?
Yeah.
Yes.
Okay, Ms. Fanning, are you ready to proceed on Mr. McClure?
Yes, I am, Your Honor. Thank you.
So we'll call his felony and then we'll handle the show causes afterwards, so that way she can continue on. Have you spoken to Mr. McClure, counsel? Are you on Mr. McClure for the show causes? Okay, no, that's fine. I just wanted to know who, just put him in the breakout room with when we're done.
I'll go interview with the person in the back, that's okay.
Well, I don't know. Do you have any other ones that are ready to go?
Mr. Jenkins.
Okay, so if you want to just hold off on just a moment, then we
Okay.
can,
That's fine.
okay. All right, let's go on the record in the matter of the state of Michigan versus Ronald McClure Jr., 26941. Counsel, your appearance, please.
Thank you, Your Honor. If it pleases the court, Attorney Andrea Fanning, P 42853, appearing with my client, Mr. Ronald McClure. Mr. McClure, can you unmute yourself and state your name for the record?
You need to
You're on
unmute,
mute.
sir.
Ronald McClure.
Thank
All
you.
right, thank you. Today is the date scheduled for the probable cause conference in this matter. And
Yes.
counsel, you had an opportunity. Okay, hold on. That's a horrible sound for that out there, for that room. All right, you did have an opportunity, counsel, to speak with the prosecuting attorney today, correct?
Yes, Your Honor. And at this time, I've advised my client of his right to have a preliminary exam. I've advised him of the purpose of preliminary exam, mainly that the assistant prosecutor would have to prove probable cause that these crimes were committed by him in his jurisdiction. After having done that, he's prepared to waive his right to a preliminary exam with the understanding that we will be bound over to circuit court for further proceedings.
Okay, so Mr. McClure, I'm going to have you unmute for each of your answers, but you can stay muted until the court's asked its questions of you, just based upon the poor sound that's happening there. Are you able to hear the court and understand myself and your attorney? Okay, you're nodding yes. Okay, very good. So, Mr. McClure, you do understand that you do have the right to have a preliminary examination where it must be shown that a crime was committed and a probable cause exists to charge you with that crime, correct? Please unmute and answer the question, sir.
Yes.
Okay. You also understand, sir, by waiving your right to preliminary examination, you will be bound over to circuit court for further proceedings on the charges in the complaint warrant. You
Yes,
understand that? Okay.
yes,
Scott, you have to push my screen forward just slightly. Okay, okay. And you also understand, sir, you did in fact receive a notice of the charges in the complaint warrant, correct?
yes,
Has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to a preliminary examination?
no,
All right, the court will note the examination having been waived, defendant is bound over to circuit court for further proceedings. You are to appear in circuit court on July 30th at 9 o'clock in the morning on the charges of the complaint warrant. Counsel, any objection to indicate via Zoom on both your signature line and your client's
Please,
signature line?
please sign both names. Thank you very much, Your Honor. And I just have one addition.
I'm not, hold on, just one moment. I'm not
Okay.
signing both names. I asked if it was okay if the court had permission to indicate via Zoom on your signature line and your client's signature line.
Yes.
Okay. And then what is it you wanted, to address, counsel?
I'm just asking for a referral to DSUs for a bond report for when we get to circuit, please.
All right, the court will refer this matter to DSU. Bond and conditions are continued.
Thank you.
Have a good day, counsel.
You
Have a
too.
good day, sir.
Thank you.
All right, let's go off the record for a moment.
And I need to do something to show where she goes.
It's gonna be in the file, Mr. Serrano. It'll be in the file.
Oh.
If it's a show cause, it'll be in the file. That's the felony one. The show cause ones, I don't know what those are. Okay. Just screen.
So we need the show cause file. Where's the file?
That's not trouble again, there.
From the floor? I didn't confirm the floor?
Yeah.
They were all with yeah, so they're probably still with there. Okay.
Now, who's Miss Mitchell to want to break out room with?
She's got two of hers here. She is still. So probably Lopez.
Does she have any that's in Wayne County Jail?
No.
Is she? I'm here. She's in person, right?
Yeah.
Okay, alrighty. All right, let's go on the record in the matter of the city of Wyandotte versus Robert Jenkins, 26388. And good morning, Mr.
Good morning. I'm just on a monitor so I can know when we're ready for.
Oh, got it. Okay, we weren't sure if you had to go on a breakout room with somebody.
Toronto P 3828 turnover happens to be Jenkins today, and set for his violation of probation matter. Sir, please state your name.
Roger Jenkins.
All right, and thank you for addressing the press release report. Today is the date scheduled for the probation violation. Your client is currently on probation for possession of controlled substance. And it's alleged your client tested positive for alcohol June 18th, June 22nd, June 30th, and July 1st. Counsel?
Your Honor, that's our understanding. He's been advised of his rights to have a hearing and advised him what the burdens of proof are. Regarding that hearing, he decided he wants to plead guilty as stated by the court to those violations. For the court's examination.
Okay, sir, I'm going to have you please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay, and you heard those allegations, correct, sir?
Yes, ma'am.
As to those allegations, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights.
Yes.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, ma'am.
You understand that by entering into a plea, you're going to be waiving some of the rights you've gone over for probation violation purposes with your attorney, correct?
Yes.
You also understand that the recommendation in this matter is for you to continue and complete all terms of probation, revoke your under advisement status, pay a $50 probation violation fee, 5 days jail, and then 60 days on the alcohol tether after you've been released from jail. Do you understand? That's the recommendation.
I did not know that, but I do know now.
You understand that this court could adopt that recommendation in whole, in part, or not at all?
So, I'm sorry.
Do you understand that this court could adopt that recommendation in whole, in part, or not at all?
Yes, ma'am.
The court could add some other terms as well. Do you understand that?
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to waive or for you to enter into a plea here today?
No, ma'am.
All right, counsel, if you can please board you your client.
Mr. Jenkins, do you agree that you were placed on a period of probation with this court? These charges? Are you on probation to this court?
Yes, sir.
Charges?
Yes.
Okay. And the allegations are on June 18th, June 22nd, June 30th, and July 1st, all 2026, that you were subjected to some random drug or alcohol tests, correct?
Yes, sir.
And on those dates, do you agree that you tested positive for alcohol in each one of those dates?
Yes, sir.
I'm satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violations indicate technical violations 1 through 4 will enter. Counsel, that's the recommendation.
Your Honor, we would hope the court would consider first and foremost, not putting him in jail today. Your Honor, he works full-time as a manager at Green Dot Stables, full-time position. He's been there for 3 years. He's also taken steps upon himself, not court-ordered, to try to engage in alcohol treatment, AA meetings. He has some lists of the meetings he's attended.
I'll take a look at those.
In addition, Your Honor, he does admit that he really voluntarily, he admits that he did have a problem with alcohol and he continues to have it. Perhaps the tether will help without revoking anything else that he's ultimately entitled to. If the court would just put the jail maybe in its collective back pocket, put it set for a jail review, then perhaps we can come back and see that he's making significant progress, continue his probation. But I told him the recommendations are just that. Just as I'm making these recommendations, the probation department has made recommendations. So ultimately, the court has to decide. We're hoping that the court sees my client as someone that could improve in the future and not repeat this kind of conduct. He tells me that if we were tested today, we would test positive for nothing. So that we leave in the court's discretion, Your Honor.
Okay.
He'll need time to pay continued fines and costs, of course, on a payment program.
Well, I'm a bit suspect of this attendance sheet for a number of reasons. One, it doesn't even have your client's name on it. And two, when I'm looking at the dates that your client's supposed to have attended these programs, it looks as though it was just filled in. It doesn't appear to have been filled in according to the dates your client has attended. And in review, I mean, I have a history of reviewing these documents.
Yes.
And the first one would be number 1 and then continue to go down this way. But that doesn't appear to be what it is. It shows July 18th, which then is crossed off and wrote 22nd underneath it. Then on line number 3, it looked to be July 16th on there, and then that was crossed off, and then that was put on number 4, July 16th, but that doesn't even make sense because July 16th comes before July 22nd.
So, did I speak, Your Honor?
Sure.
So the 16th, that was my first day to going to the meeting. I didn't bring my notebook with me, so when I went back on the 26th, the lady, Miss Coach, that's why she put her number down. She had a messed up pen. She put the wrong date, so she crossed it out and put the right date on there. And then I had she put the next day because I didn't bring my photo with me on a Thursday. So when I went Thursday, when I came back, she signed it for that Thursday. So that's why it's underneath it and not on top of it.
But why is your name not on here?
Oh, that's on me. I didn't put my name on there.
Okay.
But this is my photo right here for it.
How often do you plan to attend?
At least try to throw 3 days off the week. I try to, on my off day, Wednesdays and Thursdays, my off days, I try to go Tuesdays, but most of the times I do doubles on Tuesdays. But if I don't do a double, then I go from 11 to 1 on Tuesdays, then Wednesdays I go twice from 11 to 1 to 5 to 7, and Thursday I go from 11 to 1.
Okay, and I'm glad you hear that, sir. Glad you're taking steps on your own to do that. I also know that your place of location,
Yes, I do. I have a counselor there.
okay, I also understand that your place of employment serves alcohol, correct?
Huh?
Your place of employment serves alcohol, is that correct?
Yes, ma'am.
All right, so how difficult is it for you to work there and not consume alcohol?
Not at all no more. I don't even, when I'm finished, I just leave out.
So what was going on, sir, that, 4 times?
That was,
4 times you deliberately violated this court's order. And not even just a little bit. A lot, because your levels were high.
That's what yes. Your Honor, so that's part of alcoholism, I would guess. I mean, it's bigger than the person itself. It needs further treatment. It's a continuing developing situation. In fact, if my client has taken any type of steps on his own, though that he wants the help. Not doing it just to stay out of jail, but if he goes to jail, that's not gonna help him unless he's tethered to a treatment program. But again, we leave it in the court's discretion.
And so if you test right now, sir, what is in your system? So back to my question, what was going on during this time frame that you were consuming alcohol so much?
honestly, ma'am, my card just got reported and I'm trying to pay that to get it out and I just got frustrated with things. So I take full responsibility for my own actions.
Okay, and I can appreciate that. So did using alcohol those 4 days, did that help get your car repossession?
It did not help. It
Right,
just made things a lot worse on my end.
correct.
He understands he should not self-medicate, Your Honor, for those reasons. That's what he wants to do.
So let me just see here. I did order you to participate in outpatient substance use counseling. Have you begun that, sir?
Yes, ma'am, I have.
In addition to the NA, have you begun outpatient substance use treatment?
Yes.
All right, when was your first session?
Let
Let me clarify, when was your first session after
I
intake?
haven't been right here.
Thank you. And I do appreciate you sharing that your probation officer may have that information shared with them. All right, so you had your intake on July 9th. Have you had another appointment since your intake, sir?
Every Wednesday at 1 o'clock.
Okay.
I go to her every week. She said every 2 weeks, but I advise every week.
Okay, so how do you get from your 11 to 1 meeting?
It's there at the building.
Oh, very, very helpful. Okay,
Yes, ma'am.
all right.
That sounds like he's being organized, Your Honor.
It does, it does. Seems as though once he was called on the carpet for these 4 violations that he is, I think, understanding that he does need to put a bit of work into it. So here's what the court's going to do. I'm going to order 5 days jail. I'm going to suspend that jail, sir. I'm going to order 60 days alcohol tether. I will continue your under advisement status.
Thank you.
Any further violations, sir, you will be serving a minimum of the 5 days I've suspended. You will have your under advisement revoked, and there may be additional jail time.
Yes, ma'am. I understand.
Understand, Mr. Jenkins, more or less, you have the jail cell keys in your own pocket. If you misbehave and do something contrary to court's order, you sent yourself. Does that make sense?
Yes, sir.
Okay, so that's the order of the court, sir. So the court's going to order you to continue and complete all terms of probation. The court will order $50 probation violation fee, 5 days jail suspended, continue under advisement status, 60 days jail, or 60 days on the alcohol tether. Are you currently on a payment plan, sir, with your probation?
Yes.
Okay, so that,
I'm paying Friday.
I'm sorry?
I'm paying Friday.
Okay, so that will continue. All right, sir, please stop over at probation and you will get all of your next steps. All right, good luck to you, sir. And nice job on all of your efforts so far.
Thank you.
You're welcome. All right, let's go, let's see, are you ready on Mr. Holmes? Yes, Mr. Holmes. So let's go on the record in the matter of the state of Michigan versus Johnny Ray Holmes, 26927. So it says defendant's not present for PCC, but he's here, he's on the Zoom.
Well, we didn't know that they would run by Zoom. So when I was talking to the prosecutor an hour ago, he was not.
Okay, then I just need for you to, I just need the document from the prosecutor's office so that I can recall that.
Yes.
Okay, thank you. All right, so let's go on the record in the matter of the state of Michigan versus Juan Sierra Jr., 251293.
That's the case.
Yes, I need you to speak to the prosecutor on that, on Mr. Holmes.
Okay.
Good morning, Your Honor.
Morning.
Robert Goldman, PA 1222, appearing on behalf of the alongside defendant Juan Sierra Jr., present in the court this morning. Mr. Sierra, would you please state your full name for the record?
Juan Sierra.
Junior?
Junior.
Okay, very good, thank you. Okay, today is the date scheduled in this matter for a restitution hearing. And I believe that the victim is present here as well, Ms. Burke, correct? Okay, I'm going to have you step forward for just a moment, please. And your name, please, for the record. Okay, I need you to first keep your hands out of your pockets, please. And if you can be a little bit louder and spell your first and last names, please.
Brittany, Brittanie, Burke, Burke.
Okay, and you've had an opportunity to speak to the prosecuting attorney today as well, correct? And counsel, it's my understanding, so today is the date scheduled for the restitution hearing date, but it appears as though from this document that there's been a resolution, correct?
Correct, Your Honor.
All right, if you'd like to state that for the record, please.
Yes, Your Honor. Having had an opportunity to further speak with the prosecutor following the sentencing that was held on June 30th, we have had opportunity to further review and discuss the restitution request that was submitted. We have reached an agreement whereby Mr. Sierra would be ordered a restitution order in the amount of the $9,132.80 as so submitted. Within that, Your Honor, we have discussed with the prosecutor who indicated he is agreeable, a payment plan in light of the amount to be ordered. That payment plan would provide for Mr. Sierra is able to place a more sizable down payment or deposit, that being in the amount of $1,200, to follow by monthly installments of at least $650. I did discuss that with Mr. Sierra as well. He did indicate to counsel that that was agreeable and feasible, and he would like to proceed with an agreement or stipulation to that restitution. If I may just further, Your Honor, I do just want the court to understand in setting this as a restitution hearing for the reasons we had discussed at sentencing, we did not want to approach or give the impression to the court that we were unagreeable or hostile to such a condition or order. We just needed additional time to verify based off the limited information we had initially been provided. We had used that time to further consult with the insurance providers just to make sure that everything as so represented in the court was proper. So for that reason, we did ask to come back, not to be difficult or otherwise, overclock your docket.
No, I appreciate that, counsel. I understand that. And so, Ms. Burke, you, are in agreement with that payment plan, correct?
Yes, Your Honor.
Okay. And that you understand, if for some reason there's that's not being paid, then you have to notify, probably the probation department, I would presume. You understand that?
Yes.
Okay. And so, counsel, is your client paying that $1,200 payment today?
The 12, yes.
Yes.
Okay. And do you, so let me just ask this question. Is your client intending to pay the $1,200 to the court today? And then the court would then send that payment to Ms. Burke as is typical if somebody were to pay restitution payments monthly? Or is your client intending to, pay Ms. Burke directly the $1,200 today and then the balance paid, via the court?
Interestingly enough, Your Honor, I don't think I've ever been asked that question, under such circumstances. If I may have just 15 seconds just to ask Mr. Sierra a question?
Yes.
Your Honor, I think, for purposes of how Mr. Sierra would make that payment, he would need to make it to the court. And then that way it would also further, verify and record for purposes of compliance with the order.
Okay. And so your client's going to pay that $1,200 payment to the court today?
Yes.
Okay, so Ms. Burke, just so you understand how the restitution payments are processed, Mr. Sierra, and in fact, any defendant pays their payment to the court as ordered. The court then makes sure that that payment is processed accordingly and then sends out a check to you, okay? The goal is to do that monthly. I don't know exactly what date of the month it occurs on. Sometimes it's based upon when the payments are received and then when they're processed and things of that nature. So what date, in fact, on that note, what date of the month are you going to make those payments, sir? The $650 per month?
If you let me do it by the 15th, that'll help me out.
Okay. Does that work for you, ma'am?
Yes, ma'am.
Okay. And so then, okay, so you're going to pay the $1,200 today, and then the $650 per month. You're going to be getting that August 15th?
Yes, yes, you are.
Okay. All right, so ma'am, if you can please just stop at the window or with probation, just to make sure that we have all of your accurate contact information so that when the checks are being mailed, they're being mailed to the proper place. Okay?
Thank you so much.
You're so welcome. Thank you very much for coming in today. Anything else, counsel?
No further.
Okay, thank you. All right, good luck to you.
Thank you.
Have a good day. Stop over at probation, sir, if you need to set up. And then counsel, are you going to submit an order with a consent order with the prosecuting attorney?
Yeah, I can certainly do that, Your Honor.
Okay, very good. Thank you. All right, let's go on the record in the matter of the state of Michigan versus Johnny Holmes, 26927. Okay, and counsel?
I'm Steve Dunn from the Neighborhood Defender Service, for Mr. Holmes, who is appearing by Zoom, and I'd like it as T45490.
All right, thank you. And Mr. Holmes, please unmute and state your name for the record, please.
Johnny Ray Holmes.
All right, and today's the date scheduled in this matter for a probable cause conference and counsel?
Yes, we're asking the court to set this for an exam. And just as a side note, Mr. Holmes will have to be brought on a writ to the court.
Yes,
In person.
of course. All right, and so counsel, are you waiving time or no?
What would be the 21 days?
Your client was arraigned on July 9th. The 21 days is the 30th.
Since I've just set one for the 30th, Judge, I'd love to have this one on the 30th as well. So I'll be here already for Ms. Coop.
Okay. All right, July 30th.
Two PM.
Very good.
at 2 p.m. All right, and sir, I know that you say that I did ask you previously when we checked you in if that you were in treatment, and you stated you were, and so how are you doing?
I'm doing well, Your Honor. Thank you for asking.
Very good. I'm glad you heard that, sir. Bond and conditions are continued. We'll see you back next week. Thank you. Witness and exhibit list by July
Thank you,
27th.
Your Honor.
Thank you. All right, let's go off the record for a moment.
She also has what's right.
Oh, okay. All right, let's go on the record in the matter of the state of Michigan versus Melissa Reyes, 26937.
May I just check to be sure she can go in that here, Judge? Just want to-
Okay, yes, okay, we'll recall this matter.
Just.
Okay.
All righty. Okay.
All right, so let's recall the matter of the state of Michigan versus Melissa Reyes, 26937. And counsel, your appearance, please.
Christina Dunn from the Neighborhood Defender Service, P 45490 for Ms. Reyes.
All right, and so today is the date scheduled in this matter for the probable cause conference. Ms. Reyes was arraigned out county on July 12th, where a $10,000 personal bond was ordered by the Ringley magistrate in the 36th District Court. Ms. Reyes is not present. Today's date was scheduled for the probable cause conference, and she is not present. And
I don't have an explanation for the lack of Ms. Reyes in the court.
all right, and given that she had a personal bond and not even a tether or really any other conditions other than no alcohol, and the court has reviewed the information it has regarding Miss Reyes, and it doesn't show that she's in custody anywhere. Also doesn't show any prior failures to appear. But so what the court will note is that defendant failed to appear. Probable cause conference. Warrant to issue after the 48-hour required, because the court doesn't have any information that she has a prior history of failing to appear. So I'm not issuing an immediate warrant. So the warrant will issue on July 27th. And the court will order a $15,000 10% bond. Okay, thank you. Thank you. All right, let's go off the record. Okay. Are we ready for the read?
Neither I'm aware of.
Mr. Stone?
She's got, yeah.
Is that, was Ms. Nichols?
Yes.
Oh, okay. Okay, let's go on the record in the matter of Haley Lopez, 25187.
She had come in, I think that's why she was following.
Yes.
Here.
Yep.
Let's see.
Are you Miss Lopez? You're not dressed appropriately for court, ma'am.
Apologize for that. I didn't want to leave and then miss something.
I'll get
I
it.
just moved and all my stuff is in boxes. That's why.
Okay, but you know better than that to come to court like that.
Yeah, so she was afraid and I'm offering judge.
We got a jacket for her to wear.
Like,
Okay, we have a jacket we're gonna have you wear, so we'll recall this matter when we get the jacket, okay? I can appreciate that you just moved, ma'am, but, okay, so we're gonna just give you a jacket before we call the case.
Okay.
All right, let's go on the record in the matter of James Root II, 24951 A. And just A.
good morning, Mayor, please, this most honorable court attorney making a appearance on behalf of Mr. Lucas, state your name and address.
James Albert Ruth II.
All right, thank you. Thank you for dressing appropriately for court. Today's date scheduled for the show cause in this matter. Mr. Root has been on probation since October of 2024 and still owed the balance of $1,320.
And Your Honor, he made a payment of $100 yesterday. He took his balance down to $1,120 because of a 20% late fee that was added on there. Mr. Root also brought his check stub in, Your Honor, to verify the fact that he's paying half of his income in child support. If you would like to look at that to see.
I'll take a look at that, yes. And do you have gum in your mouth, sir? If you do, there's a tissue underneath there. You can take it out.
Thank you.
You said the balance is $1,100?
$1,120, Your Honor. It would have been lower, but because of the $220 late fee that was added,
Okay.
paid on the $220.
Okay, so,
Believe you, did you highlight that at the bottom?
The orange.
The orange part, Your Honor.
it's not half. It's a significant amount, but it's not half. How many children is that for, sir?
3.
So what is it, like 40%? I didn't do the exact math.
Yeah, I mean, it's a high amount for sure. Does that include some arrearages as well?
Yes.
Okay. Okay, so, sir, what is your current monthly, well,
He makes 18 an hour, but once they, they calculate the child support out, but he brought that in to, it's verified.
Yes.
Writing, Your Honor. And I was wondering, is there anything that you could possibly waive on there? I know that some cannot be waived. I didn't know there was any possibility to waive any fees for him. He has, twins as well as another, child, Your Honor. So we're asking to see if you can lower those by anything.
well, I mean, the only thing I think that could have been waived would have been the probation portion for early discharge, which I believe was waived, right? Did you, discharge early from probation?
Yes, I did.
Right, so then that would have been, waived. So the initial, wait a minute. All right, so you were sentenced in October of 24. You're discharged September of 25, so you didn't discharge early. You did not discharge early.
I thought it was a month early.
Well, she prepared it a month early. Well, really not a month early, 2 weeks. And that's because you had a probation violation in August, and maybe even then you must not have requested early discharge.
And Your Honor, is it possible,
Oh, he also had another violation in July, but, okay.
it says, cost to the state and close the matter out?
I will, I'll reduce it by $200, sir, on the court costs, or on the court fine.
I really appreciate that, Your Honor.
So your balance is now $920. How much are you paying per month and what day of the month works best?
If we could, do it for the middle of the month, $50.
Okay, sir, had you communicated with the court about your struggles or your challenges and requesting a different payment plan, we could have worked with you. You wouldn't have had to worry about coming in on a show cause.
I understand. I just had a couple months struggling financially.
And I can appreciate that, sir. That's why if you communicate with the court, send an email into the court, come on in, something, and ask to set up a payment plan, we can work with you. But just ghosting us doesn't really give us any information. All right, so you just made a $400 payment. I'll have you begin this September 18th. That's the third Friday of September. Does that work for you, sir?
Yes.
Okay, you won't have to come back unless you miss a payment. Sir, if there's something that arises that is throwing you off a bit more financially, that's something that's not avoidable, communicate in with the court.
Well, yeah.
All right. And have a good day. You can even get information about paying online if you'd like as well.
Thank you.
All right.
I'm very happy.
All right. The court's going to go on the record in the matter of John Stone, 24404.
Good afternoon, good morning, may it please this most honorable court, attorney Mitchell appearing on behalf of Mr. Stone, statement.
John Stone.
Good morning, sir.
Morning, John.
All right. And so, this matter, Mr. Stone is here because he, has a balance of $1,720.
That's correct, Your Honor.
All right. And so, what are you proposing?
Mr. Stone states that he made a payment of $50. Today, he made a payment of $50, Your Honor. Mr. Stone states that you are very familiar with his case and his situation, and that he's been in here numerous times before, Your Honor. And that, this has been years of struggle for him, the underlying alcohol issue. And, he has two cases. He has one with the balance for restitution. He stated that you told him that was like very, very important. So he made a $400 payment.
I paid $250 today total. I put $200 towards the case with restitution. I didn't even notice that that case number wasn't involved with this summons. So I put $200 towards the restitution because what you had said, and $50 towards the other.
Right, because I do feel that victim's restitution is much more important than the court payment. Not saying that the court payment isn't important, but yes.
So he did try to make an effort despite the fact that it wasn't a case number. And so he did put a little on both matters, Your Honor, and we're just asking for continuation of more time to pay. And if it is any possible payments that you can take off, we would appreciate that. And do you know the balance of the other one? Because he has both of them right here, so I can tell you.
They're almost the same. Balance is $16.35.
1635 and the 21/1942, and then 1670 on the 404.
Okay. And so, Mr. Stone, first off, how are you feeling?
Feel good. You know, I don't know if you can see that in there, but when I got my tether off, Calhoun County came and got me, Huron Township came and got me.
Okay.
No,
I don't see all that.
Oh, okay.
No.
So,
No, because it's for a show cause and not, one of the other charges that you've been here on before in that realm, then I don't necessarily get all that information, but
so these like 7-year-old cases that, you know, have been,
just keep your hands on your pockets.
these 7-year-old cases are, people come front and center, so I've had to do those finally.
Okay,
Been expensive. Don't have it.
well, I understand that. And so how is your recovery going?
So honestly, it's going really great. Donovan's graduation party was success, a lot of temptation, but I mean, even though it was there, I had the slightest, not at all, like drive to want to, you know, include myself in that type of activity. I just really got more pleasure out of watching everybody else have a good time, with Jessica and mine, you know. It was, I mean, it's probably the hardest situation I've been in, but it didn't, like, I didn't want to at all. You know? I felt better than not. And,
That's good,
you know,
because you and alcohol are not a good mix.
no, I'm like that since alcohol poisoning at 13.
Yep. So hopefully now you've realized that that's just not even an option for you.
You know, I do, and, you know, to sit here and say that, you know, I got it figured out would probably, you know,
You disingenuous?
I mean, I've had it figured out for 2 years at one time, 18 months recently between these two case numbers, like it's. But today, sober, healthy, you know, I had nothing but, you know, good intentions and see what tomorrow is.
Yeah. Yep. And every day is a challenge.
It absolutely is.
Right. So good. All right, sir. So today is the 23rd of the month. And so you paid $50. Can you pay $50 every month on the 23rd?
On this case specifically?
Yes.
Yes.
Okay. And then we'll see how your payments go. I'm making a note, if your payments are timely and no missed payments, court will waive $200.
Appreciate that.
Okay, have a good day.
Thank you.
Good luck to you, sir. Okay. All right, let's go on the record in the matter of Haley Lopez, 25187.
Good morning, Mayor. Please, as most honorable court attorney Ringham is appearing on behalf of Ms. Haley Lopez, who will talk now. Please state your name for the record.
I don't know that we picked you up.
Oh, Haley Marie Lopez.
Sounds like you're very loud back there. You're super quiet right here. All right. Well, the jacket looks nice on you. Okay.
Second looks stylish.
It sure does. Okay, look at that. Oversized suit jackets are the thing right now. All right, so we are here for Ms. Lopez's jail review and probation violation.
Your Honor, as it applies to the VLP, she wishes to plead guilty with an explanation. She did write a letter that she'd like to read to the court.
Okay, so let's start with this. Have you please raise your right hand. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, yeah.
All right. And you understand the allegations that you failed to appear for workforce twice, correct?
Yes.
You tested positive for marijuana on July 10th,
Yes, sure.
and that it's alleged that you failed to pay as well.
Yes, sure.
All right. And so as to those allegations, how do you plead? You understand as well that your advice of rights for probation violation purposes, correct?
Yes.
I'm sorry?
Yes.
And you understand that by entering into a plea, you'll be waiving some of those rights, correct?
Yes.
And you also understand the possible penalty as a result of your plea.
Yes, Your Honor.
And the recommendations for you to continue to complete all terms of probation, 15 days jail, suspended. Do you understand that?
Yes, Your Honor.
Knowing, and you understand this court to adopt that recommendation in whole, in part, or not at all?
Yes, you gotta speak like that. Oh, no, she's not even understanding.
Yes.
Yeah.
Yes, sorry.
That's all right. Knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right, and counsel, if you can please run to your client.
As it applies to the case, ending in 187, were you placed on probation?
So you need to speak up, please.
Yes.
Pretend like you're talking to me from over there about your movie.
She's a little nervous, Your Honor. Were you placed on probation for this case, ending in 187? Yes. Were you ordered to partake in certain programs? Yes. Would one of those programs be alternative workforce? Yes, it would be. Did you attend that program? No, I missed. Okay, and were you ordered to attend that program a second time? Yes. And did you attend the program a second time? No, I did not. And were you ordered to test for marijuana and other drugs? Yes. And did you test dirty for marijuana? Yes, I did. You were also ordered to pay court costs and fines. Did you pay those court costs and fines?
Yes, no, I didn't at first, but I did today when I came in.
So you made a payment today?
Yes,
How much did you make?
$250.
Are you satisfied?
The court is satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to those matters indicate technical violations 1 through 4 will enter. And counsel?
Your Honor, before she reads the letter to the court, I would like for you to know that she does have one son that's 6 years old. She's working at Ted's Coney Island. She has mental health issues. I'm not sure if she put that as part of the original probation order. I explained to her that she needs to tell people from the beginning. She states that she was diagnosed with bipolar anxiety and that she's on medication. And recently she ran out of meds and that due to financial obligations, it's like $1,000. She said to get one of the medications was too expensive for her. She does have a doctor's appointment. What's the name of the medication?
It's called Vraylar, and with the
Right. Thank you.
they did offer coupons, and it was still $300 a month, which was kind of still a
Have you
little.
contacted DWIN or spoken to your treatment provider?
No, but I have an appointment on Monday, and they're supposed to give me a generic
Okay,
med.
okay.
So we're hoping that she can get back on track with her medication, Your Honor, and also on track with this case. So we're asking that you continue her on probation.
Did you look into the treatment court when you were here previously? Was there any discussion about that?
That's why I told her she would have been under mental health court versus other courts, and it's different, requirements per mental health treatment, and that she needs to divulge that information, especially in situations like this, Your Honor. She was a little hesitant to tell me, but I always ask my clients, do you have any mental health issues? Because I think that's important. I ask about
100%.
mental health issues, employment, and so I wasn't aware if the probation officer knew that or not.
Well, there was that note in her pre-sentence interview. And I don't know if her attorney spoke to her about participation in treatment court, or I may have even asked it at sentencing and it was declined. I don't recall. That was in January. But I'll hear from you, ma'am. Just please keep your volume up, okay?
Okay. Before I start, I just want to tell you that I do take full responsibility and accountability. There's no excuses. I'm just explaining. This last month has been kind of hard for me.
Okay, there are tissues underneath the podium there if you need it.
Okay, thank you.
You're welcome.
Dear Judge DiSanto, I wanted to write this letter because I am truly sorry for violating my probation. I know probation was a privilege and a second chance, and I know I let the court down. I'm not writing this to make an excuse. I just want to explain what happened and let you know where I'm at today. The biggest thing I struggled with has been my transportation. At the time, I was living in Allen Park without a license and getting to my workforce program and other probation requirements depended on finding rides. I know that was still my responsibility and I should have found a way, but transportation has honestly been one of my biggest obstacles. Because of that, I made the decision to move to Riverview, closer to my mom, so I have a better support system and much easier way to get where I need to be. I wanted to remove the problem instead of continuing to let it affect my probation. I'm also catching up on my fines and costs when I go in to take care of this already. And plan to stay current moving forward. I also want to apologize for the marijuana. I saw the recent Michigan Supreme Court decision and honestly believed it meant I was allowed to use it while on probation. Looking back, I realized I should have never assumed that. I should have asked my probation officer first. That was my mistake and I take responsibility for it. I have pain in my feet and legs that I believe comes from the damage I caused to my body from past substance use. It mostly feels numb and pins and needles feeling from time to time. Marijuana temporarily helped it with that pain a bit, but I understand that doesn't make it okay. I should have handled it differently. Which I did go to my PCP and they recommended me to a neurologist and my B12 was low, so I'm taking B12 supplements too.
Very good.
Since removing the old crowd, alcohol, cocaine, and other drugs out of my life, everything started changing for the better. I'm building my relationship with my son, and that's the thing I'm most proud of. I'm present for him every day, and I'm becoming the mom he deserves. I'm working. I attend AA without being sentenced every Friday and Saturday. I'm working.
You can take your time.
Getting my license back and I'm ready to apply to college this fall because I finally know what I want to do with my life. I enjoyed starting. I even enjoyed the little things that I never used to, like cooking. I keep my home clean and I'm trying to build a normal, healthy life with routine and structure. I know those things probably sound small, but for someone who spent years making bad decisions, they're a really big deal to me. This is the most stable my life has been in a long time, and I'm proud of how far I've come, but I also still have more to prove. I understand there may be consequences for my mistake, and I accept that. I just respectfully ask that you consider everything I'm doing to change my life. Going to jail would make it difficult for me to keep my job, continue building my relationship with my son, and moving forward with everything I've worked so hard to build. I know I can't change what I've already done. All I can do is keep showing through my actions that I'm not the same person I used to be. Judge DiSanto, I'm asking you to please consider giving me an opportunity to finish probation successfully. I truly believe I'm headed in the right direction. I don't want to lose the progress I've made. Thank you for taking your time to read my letter in consideration.
Okay. So a few things. One, you're correct. Probation is an opportunity for you to use the conditions that the court put forward to modify your behavior.
Right.
A couple things that I noted when you were speaking is that you let the court down. No, you let the court down. Let yourself down. You're correct. You're correct. Further, the Supreme Court decision. So you're correct. You should have communicated with your probation officer. But also that Supreme Court decision wasn't just a carte blanche permission slip for people to use marijuana. In fact, what that decision is that if the Federal Controlled Substance Act is the sole basis for somebody's violation, that's improper. It doesn't remove court discretion as far as the requirements to make sure there's a bona fide patient doctor relationship and that doctor is recommending marijuana as the course of treatment. And I think it's like 5 things that this court requires to be in the letter from a treating physician. The court doesn't even require somebody to have their card. Now, you may need your card for other purposes, but for this court's purposes, for probation or under this court's supervision, I don't even require the steps for you to go to get your card. But there are about 5 points to make sure the letter contains. And which is all within this court's discretion.
Right.
So not having used marijuana for a bit and then using it that day, how'd you feel?
I didn't like it. I really didn't. I did it because of what I was talking about, what I seen the doctor for and stuff, and I know I should have gotten my med card. That's a whole nother thing. I need to get a state ID, and I'm not gonna do that, like I said. But when I did it, I did not feel good. I felt weird. It did take the pain away, but I don't like that feeling. It heightened my anxiety, and I'm off my anxiety meds, and it did not make it good.
So it's good that, that after not having used marijuana, I'm not saying it's good that you violated the court order, but that was a, what's the word I'm looking for? A, productive exercise, so to speak, because you were able to see that you don't even like how you feel when you use it now.
That's like when you have sugar, you go without sugar and then everything tastes like syrup when you go back to having
Right.
sugar again.
Or when you're eating clean ingredients and then you eat some of the fake ingredients that are being put into the food sources, and then you can definitely tell the difference, but you don't know that difference when that's just all that you use. So on that note as well, that you think that these things sound small. You have written that. Those aren't small. Those aren't small at all. Because those are deliberate decisions and choices that you're making to improve your own health.
Yeah.
Those aren't small at all.
And just sounds normal for most people, but like I said, after so long of not doing the right thing.
Well, really, what's normal for anybody, right? I mean, you know,
Yeah.
you never know, right? It may be something as simple, maybe not small, but as simple as making sure you're going to bed at a certain time every night so that you can get the proper amount of sleep, right? That's not small because it's a big thing. It may be simple to say, oh, let's set a bedtime, but it's not necessarily simple to achieve that.
Right.
So don't discount all the stuff that you're doing.
Thank you. I appreciate that.
You're welcome. Are you interested in the mental health court?
I am, but am I gonna keep my progress that I've made, or am I gonna have to start all over again?
What do you mean?
Am I gonna keep the progress that I've made? Cause I know I've had this violation, but she did say that if I got all my stuff done, I could get off halfway through.
You could, well, so your halfway point is 12 months because it was 24 months probation. So all cards on the table, it would extend that time. But do you know what treatment court is? Okay. So what treatment court is it is a huge support for you, right? So it helps maintain your accountability. When you're struggling, we have a team that you can reach out to for additional resources. And then within that program, there's also a portion of it that it's called MRT, which is moral recognition therapy. So it helps get to the root of why you have those struggles.
Okay.
I can tell you that we've been in operation for almost 5.5 years. We're over 250 referrals, I think, because they can come from different courts even. We've had 22 graduates from the program, 0% recidivism. So the program works. It works.
Is it here?
Yes.
Okay.
It's here. So it's local for you.
Right.
So what I would like for you to do is, if you're interested in it, I'll have you speak to our coordinator, and you can see if it's something that you're interested in doing.
Okay.
So, because you can be sentenced there from your probation violation. Okay. So what I'm going to do then is I'm going to adjourn the sentencing on this matter, and we'll adjourn the jail review to the end of August. Because that way you can communicate with the coordinator And then you can also, get, determine what that is.
From Courtney.
Oh. Okay. Well, we seem to be at capacity as of yesterday. So, so that takes that out of the realm of, there is also, sobriety court, which is local, so it's similar, but not necessarily, in depth for mental health treatment.
Okay.
So there is also a mental health court in Wayne, which I don't know if they allow remote proceedings or not. So I just give you those options so that you can explore that.
Okay.
And then when we reconvene at the end of August, you can decide what it is you want to do with one of those. Okay? Okay. So let's set this for. Can we fit this the last week of August, Ally? Or the first week of September?
We can do the last week, August, we can do the 27th,
Okay.
and then. 8:40.
Okay. So we'll see you back August 27th at 8:45 AM. Keep up all the good work that you're doing.
I really appreciate it. Have a great day.
You as well.
Thanks.
Just make sure you leave the jacket here.
Okay.
As much of a statement as it is.
And we emptied the tissue box already.
Okay, thank you.
Thank you.
So there's that. And then we are on the record in the matters of Mr. Serrano. Do you have Mr. McBurr?
Yes, Your Honor.
Okay. We are on the record in the matters of. Let's go off the record. Ms. Grady? Attorney Grady?
Yes, good morning.
Good morning. Why are you on Zoom, counsel? Are you here in person?
I'm at downtown circuit court, a couple cases.
Okay, ma'am, counsel, we handle these in person.
I don't have that on my order. I'm sorry. It doesn't say that.
When were you, appointed? When were you appointed?
1 second. I gotta. There's actually no date on it. It's not signed. I'd have to look in my phone if you want me to.
Yes, please.
Okay.
Did Attorney Carson show up yet? From Mr. Lewis?
I do know that I was not, I had no response, I know, from the client. I might have known if he called me back, but he didn't. I'm on the phone with him right now, though. He's there in person.
Okay, so counsel, when did you, I'm just looking to see when you received this notice.
I think it was, July, the middle of July, around the 15th.
Okay, so you were not spot appointed.
Not dated, though.
And you're saying that notice doesn't indicate in person?
I don't have a notice. It's just a request for appointment that they send me in my email. And nowhere on this does it say that.
Well, does it say Zoom?
No, it doesn't say that either.
Because it's in person, and I know that there was a communication sent out from appointed services to all the attorneys as well. But no, these are all in person. So what time are you able to be here, counsel?
I'm sorry, I didn't hear the last part.
What time are you able to arrive
From downtown, I'm not sure how long it takes, Judge.
Are you done with your matters down there?
Yes, I just finished.
Okay, perfect. It's about 25 minutes, so we'll see you in just about half an hour or so.
All right, sure.
Thank you.
You're welcome.
Okay. Okay.
Apparently, Mitchell was just, I think, talking to Carson. I think she's gonna stand in for
Okay,
her.
Stand in for Miss Carson.
okay, we'll put you in a breakout room, Mr. Lewis, then. He's in the Wayne County.
Mr. Jones is in the lobby.
Yes, his attorney is making her way here from downtown.
And then, Miss Yost is here and her attorney's talking to Mohammed. That's-
Okay, who's your attorney?
Well, I don't know. She wasn't sure either and he's in there, so. That's it.
Okay, and then, Ms. Dunn, did you get to speak to Mr. Campbell yet?
I'm waiting to go to people that, it's just that interrupted. So
Okay, thank you.
ready?
I'm ready to speak to him, I'm ready for the prelim, either way.
Okay,
I just want to say hello to the country.
I'm gonna put him in a room here, so if you wanna wait out in the lobby, I'll come out and get you in.
Very good.
Put her in.
Okay, and counsel, good morning, which matter are you here on?
You have Sharp there?
Oh, Ms. Charbonneau, okay, yes, all right. Okay, and then Mr. Serrano, I have you there as well. All right, so let's go on the record in the matters of Ronald McClure Jr., 1839224, 171212, 18937.
Your Honor, good morning, Richard T. Serrano, P. Your Honor, today I appear as a counsel on behalf of Mr. McClure, who is presently in custody. And this is the date and time set for various show causes on these matters.
Yes.
Please state your name, sir.
Yes, Ronald McClure.
All right. And so, Mr. McClure. Now, show causes for failing to make payments. It appears though your client has bigger issues at this point, given his charges and whatnot. And so counsel, what we can do is we can adjourn these over to the 30th with the other record. But
What other matters are pending from that?
has a felony that's set for an exam next week.
I see. That's in the court's discretion. He recognizes that he has to make payments. He's not sure of the total amount in all three, but he's willing to get on a payment program.
Yes, but that payment program's difficult to assess.
Put her in
Yeah.
Oh, that's right. Sorry, he was found over. Sorry. That's right. That was the standing stuff.
All right.
Well, it's pending, but it's pending downtown now.
Understand.
Okay, Ally, can you tell me on the 18937 matter, how much is owed? In fact, on all of them, but that's what I have first.
18937 is $624.
$624, okay?
Yes. 18394 is 480. And then 171212 is 374.
I'm sorry, 374. Thank you.
All right, here's what I'm going to do. Your client's being bound over downtown, or he's bound over downtown. He's in custody. The court's going to set aside the show cause and fines and costs and close these matters out.
Thank you very much, Your Honor. You understand, sir?
Yes.
Okay, good luck to you, sir.
Thank you.
What's your name? Slade? Yeah.
Okay.
this.
Let's go off the record. How many custodies do we have anyway? I didn't even ask anybody. Do we have any for,
One that's a right now, the paperwork, there's 3 total, but.
oh, 3 total? Okay. Nice, light day for that. All right, let's go on the record in the matter of the state of Michigan versus Eric Charbonneau, 261009.
Good morning, Your Honor. Attorney Ryan Ramsey, P 73195, on behalf of Mr. Charbonneau. Sir, can you identify yourself for the record? Eric Charbonneau.
All right, thank you. Counsel, your P number, please.
73195, Your Honor.
Okay. All right, and so today is the date scheduled in this matter for the probable cause conference.
That is correct, Your Honor. I did just receive from the prosecuting attorney a video release. He indicated they should be over to me shortly. This is a matter in which the assistant prosecuting attorney believes, and I believe as well from dealing with Mr. Bresnahan, that there should be some resolution. Mr. Bresnahan's resolutions, as Your Honor may be aware, on a true third offense generally would include the possibility of a reduction down to a second offense, but also have a participation in a sobriety court as one of the conditions. My client resides in Trenton. That would be the Woodhaven 33 District Court. I was wondering if Your Honor would consider allowing him to participate in that sobriety court there, or if Your Honor has one here that he could possibly.
Okay, so let me clarify a few things. You're correct, from this court's knowledge of the resolutions that come before it when there's a deviation request, it typically involves treatment court. 33rd is not a regional treatment court. So regional treatment court is a treatment court that can accept referrals from outside courts. 33rd and 34th District Court are not those. 33rd, likely because they already have 7 communities. 35th or 34th because they already have 5 communities in the airport. So, so there's that. So when I was shaking my head, 33rd is not one that your client would be eligible for because the case is not originating out of 33rd.
Right.
This court does have a treatment court. Our court is a mental health treatment court, not a sobriety or drug court. Also, we are at our capacity. We are full. There is, however, 25th District Court, which is in Lincoln Park, which is drug and sobriety. So it's sobriety court, it's drug court, it's both. 23rd District Court is in Taylor. That's an option. And I believe 19th District Court in Dearborn also offers a sobriety court.
I do not know about the 19th. I know about Lincoln Park and Taylor.
Yes. So you may want to explore all of those options.
Absolutely.
Because obviously you have to stay within Wayne County since you reside within Wayne County. And I believe that most of the treatment courts, you have to be at least in the same county or jurisdiction or vicinity. Okay. So that just to clarify.
I appreciate that, Your Honor.
Those options.
Oh, and additionally, Your Honor, I do advise my client to his right to have preliminary examination of the PCC within a certain amount of time. He does understand his right to have those dates. He would be willing to waive any time restrictions at this time.
Okay, very good.
And that is correct, sir?
That is correct.
All right. And so time being waived, the court will adjourn this matter. You're asking for at least 3 weeks, correct?
I get approximately, yes, Your Honor.
Okay. That may be more because we have different coverage that day. So we're trying to keep the dockets as
Understood.
possible.
I'm more than happy to take a little extra time and give him a spreader.
August 13th at 8:45.
Is that docket, docket now still is the 12th?
I'm sorry.
Is that docket not a full one right now?
That guys get all about.
Yeah.
I didn't know if it was possible to the following week though, Your Honor. Yeah, I know it's a little bit longer, but the 13th, I do have sentencing in front of Judge Hardig at 9. I would probably be able to come down around 10:45. Otherwise, I am open on the morning of the 20th.
Okay, do you want to do the 20th, Ally?
You don't have to.
I think that's being held at 28 District Court that day.
On the 20th or the 21st?
Well, so it'd be the 21st, council, because 28 District Court is covering our docket that day.
That's the 21st will be available as well.
Does that work, Ally?
I'm pretty sure that they scheduled, but if it's not, it works. But if that doesn't work, we could do 10:45 on the 13th as well.
All right, let's do the 21st for right now, and then we'll get confirmation. We'll do the 21st at 9 a.m. And I'll just get confirmation. I'm gonna step off here for a short break and get confirmation from on that matter
Yes.
before I tell Ally the wrong thing. All right, and so sir, if you're to test right now, what is in your system? Is that something you're prescribed?
Yes. I would also know he's scheduled to go into intensive outpatient treatment starting next Tuesday. To your list, you can get.
You're good. And you have the alcohol tether, sir?
Yes, I do.
Okay. All right, bond and conditions are continued. We'll see you back on August 21st at 9 a.m.
Thank you very much. All right.
Thank you.
Sound good? Possibly?
Southgate, yes. If there's something different, we will communicate that with you.
Absolutely. Either way, you're moving forward. Thank you.
All right, let's go off the record.
Break. All please rise.
You can hit mute too unless, they have to talk to somebody.
Hey guys, I have a question.
Yes, go ahead.
Hey, do you know how long I guess the inmates was saying that she's gonna be gone for hours or something like that?
No, she's talking to somebody from Indigent Services.
Okay.
So it shouldn't be too long.
Okay, I was making sure. I don't trust what they say.
Okay.
All right. Okay, I apologize for that delay. I ended up having an impromptu meeting occur. So, okay. Ready, Ellie?
So that's the exam. Do you want to do that first?
Oh, okay. Let's do these three and then we'll pull out Mr. Campbell and get the example and stuff. Let's go on the record in the matter. Oh, we need Miss Mitchell. Miss Mitchell?
She's not here.
Let's go on the record in the matter of the state of Michigan with Amber Yost, 26942.
Good morning, Judge DiSanto, we over on behalf of Ms. Yost. It's her first appearance. Asked the prosecutor for discovery, I believe he sent it to me, so but I was going to see what we're going to go.
Okay. All right. Good morning, or good afternoon, ma'am. Your name for the record, please.
Amber Yost.
Okay. And so, counsel, I see that we have your appearance in here. I need your P number, please, for the record.
Oh, sorry, 48670.
Okay. And then, because there is already an appointed attorney, just so you, know, moving forward, there would have to be a substitution of attorney. Okay.
I asked my client if she said she appeared by herself on arraignment, so I don't, who,
No, well, so she did not appear by herself. There was an appointed attorney for the arraignment purposes, but then, Neighborhood Defender Services was assigned, in this matter. So, but, we'll proceed as is at this point because there was not, and nobody from NDS actually appeared prior to today. Not that they failed to appear, but there wasn't a court date to appear for. All right, and so counsel, you're asking for an adjournment? Did you speak with the prosecutor?
I did.
Oh, there it is. Okay. All right, so I see there's a request for adjournment for 14 days. There's not a docket in 14 days. So do you want to go to 21 days, counsel?
How about a year?
Well, we're not doing that. Scale would not like that.
Okay, 21 days.
August 13th at 8:45.
And counsel, if you can go over time with your clients, we'll be past the 21 days.
Discussed this matter with her at length yesterday. She understands she was ready to do an examination and told her that we requested an exhibit for discovery and she had no problem with that.
Okay, I'm sorry, what time did you say that was, Ellie?
8:45.
8:45. All right, time being waived on the record, the court will adjourn this matter to August 13th at 8:45. Bond and conditions are continued. For your test right now, ma'am, what's in your system?
Okay.
All right, you have the alcohol tether on?
Yes.
All right, very good. Okay, we'll see you back in just a few weeks. Thank you. Have a good day. Okay, can we grab Miss Mitchell? Please. All right, let's go on the record in the matter of the state of Michigan versus Lorenzo Bartley Jr., 26191.
Good afternoon, Your Honor. Gary Cheney on behalf of Mr. Bartley.
Good afternoon.
Good afternoon.
Good afternoon. Your name for the record, please.
Lorenzo Bartley.
All right, thank you. And today is the date scheduled in this matter for sentencing on your client's plea to an amended charge of operating while visibly impaired. The original charge of operating while intoxicated second offense was dismissed by way of resolution between counsel. And counsel, did you have an opportunity to review the report and recommendation with your client?
I did, Your Honor.
All right, and are there any, as the PSI, is that accurate? Are there any questions that need to be made?
Actually, it's accurate, Your Honor.
All right, and as the recommendation, counsel.
Judge, I talked to my client at length about the incident. I'd like to point out to the court that he wasn't just
whipping up and down the street. He was trying to sleep off what he found out when he felt that he was overcome by alcohol on that evening, and he pulled over to the side of the road and was sleeping. I'm not trying to excuse the act in its entirety, but by way of mitigation, he did try and do the right thing by pulling over to sleep it off. I'd ask the court to give him a period of probation. How my client works, he takes care of his mother while he's in Detroit. He's got a family in Georgia. He flies back and forth between here and Georgia to take care of his family. He's got a good job. Here, he was given a permanent job, and more or less, I'd call it a promotion, but it was where they put him in a more permanent position. Again, he's been just working regularly, been taking care of his family, hasn't been drinking. He's gone to a couple of AA meetings. He's just maybe looking for some directions from the court. He didn't do any. He's ready to follow any of the court.
Ready for what?
He's ready to follow any orders of the
Oh,
court,
follow.
and he's not drinking, Judge.
All right, so,
Or to give him a chance.
well, okay. So you reside in Canton. And where were you at? Where were you at when you consumed the alcohol?
Actually, I went to a play.
Went to a play?
Yeah. Phantom of the Opera,
Okay, where was that?
downtown Michigan.
Downtown Detroit.
Yeah, downtown Detroit.
Okay. How did you end up in Wyandotte?
Because when you stayed on 75, actually, I had somebody with me. I dropped them off
Where'd you drop them off at?
on the burner, and
Okay, so Southwest Detroit.
yeah.
Okay.
And then I got back on the freeway and I went the wrong way. Yeah,
Presumably because you were .172.
correct.
And when the officers arrived, you had driven up over the curb and onto the grass. So technically, I guess he was parked, but not really in a parking spot.
Yeah, I mean, I'm certainly not arguing with court, Judge. He went over to the curb, maybe went over the curb, and he pulled over, parked, and went to sleep. About to say one time, yeah.
Sure.
When I pulled over to the side, it was a grassy knoll, if that's the correct verbiage. It wasn't a curb. And I just thought it was.
At Biddle and the Antoine?
Pardon me?
At Biddle and the Antoine, those are curbs over there. We don't really have any grassy knolls.
There's snow out there, Judge. It's dirty. Again, Judge, we're not taking this with the court's analysis here. But he did fall. By no means I'm saying I was right.
Right, especially since this is really your third offense. You had one in Georgia, reduced to a reckless driving. And then you had another one in Georgia in 2021. So pursuant to statute, MCL 257.6259B, the defendant must be sentenced to either not less than 5 days or more than 1 year in jail, or community service for not less than 30 days or more than 90 days. How long have you resided in Detroit, sir? Or in Michigan, I should say.
I've been in Michigan a year. My mother got sick about a year ago. And so me and my sister was taking care of it, but my sister was in transition of moving to Georgia with me. So I had the better offer to get a job here at Ford Motor Company. So I came and got a job at Ford Motor Company.
So is your wife and children moving up here?
No.
The summers are a little bit more mild.
We were originally from here, but my wife has a great job in Georgia at college, and our kids, 13-year-old, is still in school, and we didn't want to take her from school to, it's a big transition. So I work here, and when I got my days off, I just block them off.
All right, well. What's your work schedule, sir?
Officially, we work from 5 a.m., from 5 p.m. to 5 a.m. like that, I'm in sleep. But I work Tuesday through Thursday, mandatory. And then every other week, I work Tuesday through Saturday and some Sundays. It depends on the broadcast.
Depends on the broadcast.
Yeah, the company sends a broadcast, we got a bill for a particular week.
Okay. And so which shift are you on right now?
I'm on B crew.
So is that Tuesday through Thursday this week?
Yes, ma'am.
So you're off the weekend?
No, Tuesday through Friday, I'm sorry.
Okay. So Tuesday through Friday means you go into work Thursday night and you're off Friday morning and then you're off for the weekend, or you go in Friday night?
I go Tuesday at 5 o'clock all the way to Friday at 5 o'clock. 5 o'clock, I get off Saturday morning at 5 a.m. Depends on if we have a meeting after work, I might get off at 6 a.m.
Got it. Okay. So the next week you do Tuesday, Wednesday, Thursday?
No, every week is Tuesday through Friday. We work 4 days a week for sure. And then depends on the broadcast, every other week, we work Tuesday through Saturday.
Got it. Okay. All right. Well, I asked those questions, sir, because what the court's going to do is, after a review of the report, the recommendation, hearing from counsel, hearing from Mr. Bartley, the court does not find that there's reasonable grounds to depart from MCL 769.5. The court's going to order 5 days jail. I will give you a report date, sir. And then upon release, 45 days on the alcohol tether.
Yes, ma'am.
That is the sentence of the court. Any questions?
Did you get any credit for the day you got arrested, Judge?
When did you post your bond? Let's see, you were arrested on February 15th. Your bond was posted the 17th. So the court will also order 2 days jail. So the court will also order, 7 days jail, credit for 2 days. That'll just read easier. All right. And then, any further questions regarding that?
Does he come to coordinate the jail time today with probation or?
He'll go over to probation, coordinate that jail time.
Okay.
So, sir, what I'm going to do is I'm going to give you until next Friday to report, because you work Saturday this week, correct?
Yes, ma'am.
So I'll allow you to report on the 31st.
Okay.
Okay, so then that'd be the 31st. So Friday, Saturday, Sunday, Monday, and your 5th day would be Tuesday. You'd be out well before you have to report to work.
Yes, ma'am.
Okay? So I'm giving you that accommodation, sir, so it should not in fact impact employment for you.
I really appreciate that. Thank you for being flexible, girl.
And I would really appreciate you not driving after you consume alcohol moving forward, especially with all the options that there are with alternate transportation.
Bad decisions won't happen again.
All right, $300 fine, $100 screening assessment fee, $300 cost of prosecution. Crime victim assessment fee of $75, justice system assessment fee of $50, so that's a total of $725. You did post a bond of $500. Do you have the balance to pay, sir, of $225?
If I could tap, I can, because I wasn't sure I didn't bring no cards or nothing with me today.
You can tap, like Apple Pay?
No, in my wallet.
Oh,
my phone.
that should be fine,
Okay.
I think.
If not, just in case, could you give them 2 weeks to pay, just in case, good, if it doesn't work, it goes window.
Indicate balance by July 31st. That way we're not getting confused with dates or anything like that. All right, so sir, stop over at probation and somebody will be with you shortly regarding your report information, okay?
Thank you,
Good luck to you, sir. Have a good day.
Again, have a good morning.
You're welcome. Okay, let's go off the record for a moment. All right, good afternoon. Grab Miss Mitchell. And then, we're gonna grab Mr. Campbell and then we'll get going with the exam. I read that case you gave me. It was an interesting set of facts.
Yeah, very interesting.
But it wasn't necessarily,
If we look at the footnote to the cases, if you're telling someone you can't freely associate with the person because it's a constitutional, you're taking a constitutional right away from them, you've got to make sure you make a clear record with it, basically saying.
because the Court of Appeals,
Right.
Supreme Court looks at it with scrutiny, correct? Yes.
That's why I think with those, that's the point of the.
See, yeah. Yeah, no, it was the whole fact pattern was interesting. First I thought, okay, I thought it'd be a domestic violence case or an assaulted case, and it was not. That was the first
Yeah, it's a drug case.
point of interest, yeah.
Right back.
All right, and so we are going to go on the record in the matter of the state of Michigan versus Jerence Lewis, 26920.
May I please, is he on this one?
Yes, Mr. Lewis?
He's a black gentleman, that's it.
He has not been on in a minute.
My Zoom went out in my room, and so he was on the screen. I don't know who that is.
Oh, okay, let's go off the record. The individual in Wayne County Jail, we're asking you to unmute, so can you please unmute? Mr. Lewis.
He had 116,
Yes, sir. Okay, let me just find out who that is here. Yes, sir. Your name, please?
Wayne County Jail, can you state your name?
No,
Which
not you,
one?
Mr. Lewis. Mr. Lewis, no, we have you. Thank you.
Mr.
Okay.
Lewis, Jerence Lewis?
Yes, we have you. Thank you. The other individual, what is your name, please?
Ronald McClure.
Oh, yes. Yeah, we already handled all that. You're all set, sir.
Okay.
Okay, thank you. I thought he was familiar, but I was confused as to why he was still there, but. All right, so let's go back on the record in the matter of the state of Michigan versus Jerence Lewis, 26920. And counsel?
May I please report Attorney Brandon Mitchell appearing on behalf of Mr. Lewis, standing in for the attorney of record Stephanie Carson, with your permission, correct?
Right, yes, ma'am. Yes, Your Honor.
Okay, and so I will indicate that this matter was originally scheduled for probable cause conference on July 16th. However, it was not called on the record. Defense counsel had already logged off. However, it was not called on the record because the court had information that Mr. Lewis was in discipline at Wayne County Jail and they were not able to bring him to the screen. So we adjourned it to today's date. All right, so counsel?
Your Honor, Ms. Carson is asking that this matter be set for a preliminary examination, and she's asking for a date on this.
Okay, and is your client waiving time?
Your Honor, my understanding is that he was past the 21 days, but I'm not sure. He was making an argument that he didn't want to waive, and I explained to him that he wasn't waiving the preliminary examination. He would be waiving the 21 days. So if someone could check for us, I'm not sure.
Well, let's see. He was arraigned on July 7th, which 21 days is actually the 28th. So Mr. Lewis, do you understand what your attorney was attempting to explain to you?
Yes, I do.
Okay, so you're not waiving your right to your preliminary examination. You're only waiving your right to have it held within 21 days.
Yeah, I don't want to waive it.
Okay, well, I can tell you, sir, that you're going to be over that 21 days ready because you were not able to be brought to the camera last week.
Right.
We could have done your exam today within the 21 days, but because you were not brought to.
I don't understand why I wasn't brought.
Excuse me, sir, please don't interrupt. Because you weren't brought on the camera, Wayne County Jail wasn't able to bring you on the camera. That kind of pushed your time out. So if you don't want to wait, he doesn't want to wait, Let's set it for July 30th.
It only hurts him, and so that's why I'm not trying to have that freedom within 21 days, so.
Okay, so we will set this for exam on July 30th.
So, Your Honor, the 21 days would be the July the 20 days, and so if we do it the 30th, that would be over the 20.
It is, however, it's over the 21 by the 2 days based upon Mr. Mitchell not being able to be brought before the court. And we only have our state prosecutor here on Thursdays.
Okay, I just wanted to put that on the road. I have
Yes.
no issue with it.
Yes.
I know how to practice, so I don't, he doesn't understand it. It's in his benefit.
Okay. All right, so Mr. Lewis, just so you're aware, you're gonna be over your 21 days by 2 days because our state day is only on Thursdays. That's the only day we conduct our state exams. It's the only day we have our state prosecutor. And as I stated before, the court is going to find good cause to go over that time by 2 days based upon Wayne County Jail not being able to bring Mr. Lewis to the camera for whatever happened over there. So.
Do you understand that, Mr. Lewis?
Yes, my preliminary examination is July 30th.
Yes. And so Ellie, what time are we doing that? All right, that's going to be at 11 a.m. Any witness and exhibit list by July 27th.
I got another question, if I could ask.
Yes, sir.
When I'm in the breakout room with my attorney, don't I got client attorney privileges? Like
Explain to
people
him
watching
that he was trying.
the video while me and my
I
attorney is
explained to
talking.
you that that's not true. I said that they can just see that we're in the breakout room, that they're not in the breakout room with us. I explained that to you already.
That's
Yeah,
correct.
you said they was watching us though.
No,
So I
sir.
said,
Sir, let me clarify something, okay?
Yes, ma'am.
When you and your attorney are in a breakout room,
Yes,
only
ma'am.
the two of you are in that room together.
Yes, ma'am.
Only the court who's operating the Zoom sees who's in the breakout room. But we are not in the breakout room with you. We cannot see your video in the breakout room. We cannot hear any conversation that's going on at all.
Yes, ma'am. I was under a different impression.
Okay, well,
I'm all set.
okay. And any further questions, sir?
Well, I was told different. I apologize.
Okay, well, maybe there was just a misunderstanding of what was stated. So the court's going to order bond and conditions are continued.
I get a bond. I get a bond.
What's that, sir?
I thought she was going to address the bond. She didn't even do it though. She told me she was.
Perhaps, sir, she was going to address the bond if this was going to be going over your 21 days. However, it's not. And counsel, is there a bond argument or no?
Question of bond, reduction of bond. That's our argument.
Okay, the bond is currently
Nothing.
remanded. There's no bond.
Exactly, Your Honor. Me and him went over that. He knows his bond. He was remanded on that bond. There's nothing that he told me that the case hasn't changed. Nothing, no further movement on the case that would change the remand. And me and him spoke upon that, Your Honor, but he's aware of that.
Okay, very good. Thank you. And the court will note that this court did remand Mr. Lewis without bond based upon a review of Mr. Lewis's criminal history as well as the allegations in this matter and the seriousness of that matter, as well as, if I recall correctly, the named victim in this matter is the same named victim in a matter from August of 25 from River Rouge, also assault. And that there was also, in this matter, a firearm that was also at issue.
And Your Honor, for the record, I would like to note that I'm standing here for his attorney of record. Ms. Carson is in Las Vegas at this time. She would not be able to be present. Your Honor, we did not want to adjourn this matter again to push him further away from the 21 days of the preliminary examination. So we wanted to hold this hearing for him. And so,
Okay, thank you. So noted. Okay, bond and conditions are continued. The court's denying the request for reduction of bond.
What is my charges?
Okay, we'll see you next week, sir.
Right. Thank you. Have a wonderful day, Your Honor.
You as well.
Here I have Mr. Eric. This is an easy one, but
We're on the record as a matter of the state of Michigan versus Eric McGee, 26705 A, B, and C.
may it please this most honorable court, Attorney Reagan Mitchell appearing on behalf of Mr. Eric McGee, who's standing to my right. Please state your name for the record.
Eric McGee.
All right, and good afternoon.
Good afternoon.
And I appreciate your patience today.
And Your Honor, this is a dismissal per prosecution.
Okay, can we get, Mr. Mohammed, can you please,
While you're waiting, Your Honor, I can give you a little background information. This is a state matter. However, the officer wrote these matters up on as a ticket offense as opposed to writing it the proper way. Mr. Muhammad does not have a case file in his system. He does not have discovery. So the officer did not write it up properly. And so Mr. Muhammad does not have the necessary documentation that he needs to move forward on the matter. And so.
okay,
Good afternoon, Your Honor. Mohammed, on behalf of the people. Your Honor, defense counsel is correct. I'm moving for a no late process. I cannot proceed with a citation only. This OWI was issued on a citation and my office is missing the necessary evidence, name of witnesses and information related to issuing the charges and proceeding with the charges. So I'm dismissing this and the police department will be notified to either submit a warrant request to my office so that we could review it or submit to the city for prosecution.
okay,
That's my understanding.
okay, all right, the court will grant the no late pros. Let me just confirm something here.
And he also say that this doesn't happen and I should frame this so that this doesn't happen too often.
All right, and so the bond conditions then are terminated, sir, and you're all set.
Thank you, Your Honor.
Have a good day. Okay, thank you. All right, let's get going, Mr. Kim. Are you ready to, let's go off the record. Are you ready to proceed, Mr. Mohammed, on the exam?
Yes.
With Mr. Campbell? Okay. All right, we will, grab him out. In the meantime, I'll grab, I'll continue with, Mr. Jones. Let's go on the record. In the matter of the state of Michigan versus Shakari Jones, 26911.
Good afternoon.
Good afternoon.
Please, the court's committee on behalf of Shakari Jones, G44567. Mr. Jones, state your full name, please.
Regarding
All right, thank you. And, how long was the drive, counsel?
Yeah,
No, counsel, how long was the drive?
Oh, it is really.
Oh, okay.
It was close.
Okay, all right. Today,
Whatever you said.
today is the date scheduled for the probable cause conference in this matter in council.
Yeah, I haven't gone over the discovery of my client. He's indicated he don't. Knowing that people have the burden to show culpable because a crime was committed, probable cause to bring charges against. He'd like to proceed onward to circuit court for further proceedings.
Okay, and counsel, I'm sorry, what was your P number again?
44567.
Okay, thank you. Okay, and so, okay, I need both of you to sign this, please. So, Mr. Jones, you have heard what your attorney stated on the record, correct? And you understand that you do have the right to have a preliminary examination or it must be shown that a crime is committed and probable cause that is the charge with that crime, correct?
Yes.
You also understand, sir, by waiving your right to a preliminary examination, you will be bound over to circuit court for further proceedings on the charges in the complaint and warrant. Do you understand that?
Yes.
You also understand, sir, I'm sorry, you did in fact receive notice of those charges, correct?
Yes.
And has anybody promised you anything, threatened you or coerced you in any way for you to waive your right to your preliminary examination?
Yes.
No, was somebody's forced you?
Anybody forced you to waive your exam?
Oh, no.
Okay, very good. All right, the court will waive examination and defendant will be bound over circuit court for further proceedings. You are to appear in circuit court on August 6th at 9 o'clock in the morning. And the court will order bond and conditions are continued. And you're all set. Thank you. Have a good day.
Thank you.
Thank you.
Pull up here.
Okay, and then who are these two?
Holbrook.
Okay, well, we'll go on with the exam first. All right, Mr. Muhammad, are you ready to go?
Yes, on Elijah Campbell.
Yes.
Yes.
Okay, let me go off the record for a moment. Ms. Dunn, are you also representing Mr. Campbell on the probable cause matters for 1011?
I am.
Okay.
If you wanted the PCC on that one first, I don't know what the court wants to do with it.
Well, I guess it doesn't really matter which way we do it because, yes, so, okay. All right, and so, okay, let's go on the record. In the matter of the state of Michigan versus Elijah Campbell, 26917.
Good afternoon, Your Honor. Mohammed on behalf of the people.
Thank you.
And good afternoon, the Neighborhood Defender Service by Christina John, the 45490 for Mr. Campbell, who stands to my right.
All right, thank you. And sir, your name for the record, please.
Elijah Campbell.
Okay, and today's the date scheduled in this matter for the preliminary examination. And are the people ready to proceed?
So Judge, we are requesting for a 1-week adjournment at this time. It's my understanding that one of the subpoenaed witnesses, so there's a number of subpoenaed individuals. I'll start with Tamia Washington, who is the complaining witness in this case. The detective in this case, Detective Garcia, was here in the courtroom, did attempt to serve Ms. Washington with her subpoena. However, she refused to accept it. And she's, my apologies. So she took the receipt of the subpoena, but she's refusing to cooperate and appear for prosecution. She does not intend on assisting with prosecution. She does not intend on appearing here today. However, she is in receipt of her subpoena. That's where we're at with the complaining witness. Now, I don't intend on letting the case be dismissed at this time just based off of her lack of cooperation. I intended on proceeding with Jayla Beavers, who's an eyewitness. And my understanding is she was intending on being here today. However, my understanding is that she had some car trouble and some issues with locating a babysitter for her child, and she's unable to be here. But my understanding is that based off of the detective's discussion with Miss Beavers, it was her intention to be here today. So this isn't something where she has denied, appearing or cooperating with the prosecution. It's something that due to her circumstances, she's unable to be here today. The victim advocate has had a discussion with me and the OIC, and it's our understanding that if the court was inclined to adjourn it a week, the victim advocate was going to assist Ms. Beavers with a car ride through a cab to be here with us next week, if that's okay with the court. So, considering the circumstances, we're respectfully requesting a 1-week adjournment.
Ms. Dunn?
Thank you. We are opposed to any adjournment, Judge. This is the date and time that has been set. The prosecutor had plenty of time to make arrangements with witnesses to make sure they would be here. That witness, Ms. Jayla Beavers, is an eyewitness. She's not the complainant, so I don't believe she's even essential to this case. The complainant herself does not want to proceed. And I believe this case will fail in the circuit court if you're a non-compliant complainant and that this court should consider that and deny this adjournment. This is the date. If the prosecutor wants to refile, it'll be an adjournment and they can just go ahead and refile. It'll be without prejudice, and they can do so. And that my client's being held on a very high bond in this case. I really just don't believe that it's appropriate to adjourn given these circumstances. That the prosecutors admitted the complainant doesn't want to be here and will not proceed to help him.
Mr. Mohammed, when did you receive notice that Ms. Beavers was having car trouble and babysitter issues?
Today, shortly before the hearing today. And Judge, just for the record, I would disagree with defense counsel's assessment of Ms. Beavers and her role in this case. I think she is essential to the case. She's a witness to the alleged criminal conduct committed by the defendant. So she's very relevant. She's testifying from personal knowledge and her own observations. The alleged conduct in this case is disturbing. And so this is our position at this time, that Ms. Beavers is a necessary witness for this case to proceed, and we're respectfully requesting a one-week adjournment.
I mean, Ms. Beavers, neither did Ms. Beavers nor the complainant call the police in this incident. Someone else called the police, they heard an argument. There was no they didn't initiate this police contact in this case.
I understand that, counsel, but in reviewing, in what I recall, at the arraignment stage and reviewing, or hearing the testimony of the officer for the signing the complaint warrant, and in reviewing the documents, it's my understanding that based upon the police report, which I know that that's just what it is at this point, that Ms. Beavers is an essential witness to the egregious behavior that's been alleged by Mr. Campbell.
If the court is inclined to adjourn, I understand we have a PCC on another file that I'm asking for a preliminary exam on. They are completely related, these cases.
Correct. They'll all be on at the same day.
If they could all be combined on the same day, that'd be great. And I'm asking the court to consider reducing my client's bond, given that he expected to have this preliminary exam today and for the case to move forward today. And now we're waiting another week on this case.
Okay, so let me just, one moment, let me rule on that first. So on the adjournment first, the court's going to grant the adjournment. The court does find there's good cause to grant that adjournment based upon the short notice that the prosecutor received today from a very necessary witness in this matter, and that the Wayne County Prosecuting Attorney's Office is committed to assisting the witness with transportation for the next hearing date, which is going to be July 30th. At this point, everybody should just pack lunch and dinner for that day. I don't even know what time, Alan.
2:30.
At 2:30 p.m. Okay. All right, and now what I'm going to do is I'm going to handle your bond. Well, this is not the file for, I need the other file for Mr. Campbell, please. The 917 file. I have the 1011 file. Mr. Mohammed, do you have that file in your office still?
Yes, it's very likely.
Okay, I think Ms. Dodge is going to get that.
917, correct.
Yes. Okay, so then let's go on the record here, 261011. Let's conduct the probable cause conference first, then we can go back to the bond request. All right, and so the court will note that the probable cause conference was held. And the request to set this for an exam, correct, counsel?
Correct.
And so this will be July 30th at 2:30. Any witness exhibit list. Thank you. By July 27th. Okay. So counsel, you're requesting a bond reduction on the 26917 matter.
I am. My client has been on tether before without any violation. I'm asking the court to consider a personal bond with a tether. He could do house arrest, correct, Mr. Kimball? We are talking about 1 week here. He's already been incarcerated for several weeks. And I just would like the court to consider that he will return to court. He does not have a failure to appear history that I know of.
Okay, you're asking for a personal bond counsel on these charges?
I am. I, especially in light of the fact that I believe the charges are likely to fail in the circuit court, given we know the complainant is not here and has expressly said she does not want to pursue these cases.
Well, if I was able to predict the future, I would have already won the lottery, but counsel, your, Mr. Mohammed, your response, please.
Judge, we oppose the defense's position. The defendant has a history, for committing crimes. And specifically, he has a prior conviction for operating a vehicle while being impaired, which to me suggests that the defendant poses a potential danger to the public. But it's not just that. In 2021, he pled to carrying a concealed weapon, which was eventually dismissed under HIDA. However, in 2025, he committed another offense and was found guilty of CCW, which he pled guilty to. So to me, his past conduct suggests that he has a disregard for the law. He has a disregard for compliance. And I believe that if it's a modification in this case, as the bond was to allow for his release, there might be a continuing of that bad behavior, committing crimes, doing acts that could potentially put the public in danger. I do want to note, even though they are dismissals, the defendant was previously charged with 5 different domestic violence cases. Now, I know they all led to being dismissed, but I think that common trend is something to take note of and to keep an eye on. Now, the defendant in this case is alleged of assaulting not just his domestic partner, Ms. Washington, but a 1-year-old child. The child in this case was 1 year old. And anybody that has, I guess, the guts to do something to a child so young means that they're unpredictable and they pose a danger to not only the witnesses and the victims in this case, but others as well. I know it's still alleged at this point, but we have evidence, and that evidence seems consistent with the police reports. And so based on that, a review of this history, a review of both the files in this case, which also include being a prior convicted felon and being in possession of a firearm, continues to show that he has a disregard for compliance, disregard for the law. And so for those reasons, I think there should be no modification as defined. But thank you.
Okay, let me ask a question. So the 1-year-old child that's a victim, who's the representative for that victim? Because at this point, if the mother of the child is refusing to cooperate, the 1-year-old child is a separate victim. So who's looking out for the interests of the child? Is there a GAL that's been appointed? Is there an appointed attorney on behalf of this other victim? Because it seems to me that there would be a conflict if the mom, as one of the victims, is not choosing to proceed at this point. Perhaps that's a detriment to her also moving forward. And I don't know if CPS is involved. Do you know the status of that?
Yes, so Judge, I did receive an update today from the detective and stating that CPS is in the process of terminating the parental rights of Ms. Washington. It's an ongoing thing. I don't have too much information about that at this time, but it is my understanding that it is something that is being done and it's currently in process at this time.
And so where is the child currently located? So not with the mom?
With the grandmother is what I was informed of by the OIC.
So has there been communication with the current custodian of the minor child of the other victim that's named? By your office, counsel?
No, Judge, this is, again, I'm only learning about the process of termination of parental rights for Miss Washington as of right now. It's not something that I was too aware of before. Essentially, the victim and the 1-year-old child is not going to be subpoenaed to testify here in court, because again, he is 1 year old. So.
Well, correct.
It's something that's outside of the realm of my knowledge at this time. It's something that the police and CPS is actively working on, and I'm sure they're going to figure it out. It's my understanding it's in the process.
Okay, well, counsel, it's not out of the realm of something that needs to be considered in this case, because you have a 1-year-old victim that needs to have somebody advocating for that child. If you have two separate victims in this case, right? You have the child abuse of the charged count 3, which is the 1-year-old child, and then count 1 and count 4 is Miss Washington, correct?
Yes, Judge, I am advocating for that victim. I don't know the extent of the CPS situation because that's not something that's been brought to my attention. But as of the preliminary exam, I requested for an adjournment so that we can advocate for both the victim, the child, the 1-year-old child, and his mother, who's already declined to be here. I intend on proceeding.
Counsel, I'm not suggesting you're not advocating for the 1-year-old, for that victim. I'm not suggesting that at all. My question is, if there is a conflict, there's a conflict somewhere. You have one victim that doesn't want to proceed, but is the parent of the other victim. So my question is, Ms. Beavers is a necessary witness for which count?
For the case in its entirety.
Okay. Is Ms. Beavers a witness to count 3? Any actions with, any alleged actions with the 1-year-old?
Yes, Judge.
Okay.
Yes.
Okay. That was my question also, because there's been statements made that Ms. Washington may not want to proceed on that matter. So I didn't know if Ms. Beavers is a witness for all counts or just as it relates to Ms. Washington.
Ms. Beavers is a witness as to the entirety of the case and what she has personal knowledge of. I don't want to get ahead of what I believe she will testify to, but she is a witness of a large portion of the interaction between the defendant and the victims in this case.
Okay, victims. Okay. And then I know that you stated that CPS is in the process of terminating Ms. Washington's rights. Is there anything going on currently with Mr. Campbell and his rights?
As of this moment, I don't know. It's only what I've been advised of. Again, that's something that's ongoing. But when my office receives an update, I'm happy to provide that to the court. At this time, all I'm aware of is Ms. Washington's her parental rights is currently being terminated pursuant to the CPS investigation.
Okay.
I think the record should reflect that my client is telling me he does not have CRUMBLE. This child has not been declared his. So there will be no CPS investigation as to him as a parent.
Okay.
I know. So, and again, I believe the people to their proofs, they still have to prove to a probable cause standard that there was any assault on anyone, including the child. And I think that's what they'll have to do next week. Okay. So again, as to bond, I will state, whatever the prosecutor said is fine, but those are allegations. My client is presumed innocent at this time. The only person who can say that there was an assault on either of these people, for both of these people, is the complaining witness. There is no statement yet. Maybe there will be from Ms. Beavers as to something else, but right now there is no sworn statement. And I'm asking the court to consider that in fashioning a bond that's appropriate.
And Judge, I will just state, and I'll quote exactly from the police report.
Again, I don't believe that that's appropriate. I think the court can consider bond.
Well, here's what this court's going to do. This court's going to consider what it's considered previously. And the court does recall that Ms. Beavers at least the information this court has from review of documents at arraignment, is that Ms. Beavers observed a lot of actions of your client, one of which is alleged to have involved a tire iron with Ms. Washington, and also alleged to have observed your client punching the 1-year-old. So that's a direct, it appears to be a direct observation. Again, it's what it appears to be at this point. And based upon all of that and all of the circumstances in this matter, this court's taken into account at the multiple court dates for this matter. No, also the prior cases that this court has had Mr. Campbell here with, as well as Mr. Campbell, I'm sorry, Ms. Washington being the named victim in each of the 5 prior domestic violence charges that were dismissed. The court has significant concerns for the safety of the witnesses and the victims in this matter. And for those reasons, the court's going to deny the request to amend bond and continue bond and conditions as ordered. I will refer for DSU counsel.
Yes, thank you. That was my next request.
All right, and we will see you all back on next week.
Thank you.
Thank you. Let's go off the record. Detective Garcia should be helping, should be here also.
Yeah, that's, I think it's really.
So you can just make one of these. How many exams are we at next week?
I'm sorry, Judge, what was it?
Oh, sorry, Lucia, and I did see you guys switch too. How many exams do we have next week?
Thursday? You're on the 23rd.
Next Thursday, the 30th.
$39.
39 exams?
Oh, I'm sorry.
No, oh, did I say cases? I meant exams. 5?
Yeah.
Oh, no, plus there's just been 3 or 4 set today. So those probably aren't in there yet.
I'm sorry.
Yeah, I thought, okay, I knew that there was a lot, but I didn't know there were that many. Okay, so here's Mr. Campbell. Let's put these together here. All right. Okay, Mr. Holmberg, are you ready to proceed on your matter? All right, did Ms. Vincent show, is Ms. Vincent in custody? Okay.
Miss Vincent, sorry, she was bonded out. She,
Bonded out, okay.
yes.
And then who's the attorney for Posey?
I was,
They don't want to be you, Judge West.
Hey.
But my last name, Ruprecht.
Who?
so Ruprecht for Posey.
Ruprecht? Okay, is that person, is that attorney here?
She's very here.
Oh, counsel, you're on Ms. Posey? Okay, so, information we have is Ms. Posey was just, sent to treatment yesterday.
Yeah.
And so they contacted the court asking to appear via Zoom. I don't know how that's going to work if you're intending to hold the exam.
I just, the nest is kind of a black hole when our clients end up there. I just need a chance to talk to her. She gets on Zoom, like,
Oh, then I'll let them know to have her zoom in and then you can put her in a breakout room.
yeah, because I wasn't able to talk to her yesterday. We may end up waiting.
It's okay.
Your Honor, is she on? We did right now.
Not yet, not yet. I'm just letting my, clerk supervisor know to let them zoom in, to have them zoom in, because she did message me asking about that. And I said, well, it's an exam. I'm not sure how that's going to work, but so knowing that you need to work, she's gonna, or you need to speak to her, then, they're gonna zoom her in.
Great, thank you, Judge.
You're welcome.
Don't worry, this is stuff.
Okay, do these.
There'll probably be
He's
more.
just sitting there, I'll tell you what happened, so he's safe.
So he's.
Okay, there's the list. Okay.
Do we have the order of dismissal for the McGee case? That he wants a copy of the order.
Is it the Nolle Press?
Yes.
The the court prepares that, or like there's a court form for that, a GIS form, and then Mohammed has to sign it, and then we can.
So that's gonna take some time. Can't get that right.
And it will probably be not today.
Okay.
Usually, Alan does it and then they sign it the next week.
That's what I thought. He's waiting. I'm gonna let him know.
Yeah, he's,
Okay.
oh, wait, I guess, I don't know.
For sure.
Okay, there's that there. Okay, and then Mr. Holmberg will do your two matters here. Okay, Mr. Ali, we're waiting for your attorney.
All right, copy, Your Honor. Thank you.
Okay. You're
Thank you so
welcome.
much.
You're welcome. Alicia, you just tell me when you're ready.
I'm all set, Judge.
All right, we are on the record in the matter of the City of Wyandotte versus Alan Laster, 26610A. And
I'll see you.
oh, hold on, let's go off the record. I hear myself.
Okay, sorry about that, Judge.
Oh, that's okay. All right, we're back on the record in the matter of the City of Wyandotte versus Alan Laster, 26610.
Yes, Your Honor, I have it over on behalf of the defendant who stands at the podium.
Thank you. And state your name for the record, please.
Yeah, no more or less.
All right, thank you for dressing appropriately for court. The color green looks very nice on you.
Thanks.
All right. And so today is the date scheduled in this matter for sentencing on your client's plea to an amended charge of operating while visibly impaired. The original charge of operating while intoxicated and open intox they were both dismissed by way of resolution between counsel. And counsel, any correction that need to be made to the recommended report?
There are not, Your Honor. We actually follow recommendations of the probation department. We just asked that the defendant tentatively take it off after he is sentenced today.
Okay. All right. The court will note after hearing from counsel reviewing the report, the recommendation. Is there anything else you'd like to say, sir?
No, sir.
Okay. the court, after, in reviewing the report, the recommendation, criminal history, the court does find that there is reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Laster and the legislative guidelines. Sir, you had a very high level of 0.187. That's a high level. That's not of alcohol. And you were trying to get all the way back to Ypsilanti?
Yeah.
All right. The court's going to order not to violate any criminal law of any of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You also, sir, are to notify your probation officer immediately of any change in address or employment status. The court's going to order you not to possess or consume any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition so the court can monitor progress in maintaining abstinence and sobriety. The court's going to also order you, sir, to participate in outpatient substance use counseling. The rehabilitative goal for that condition is so you can further receive assistance in providing coping mechanisms so you can maintain sobriety, hopefully preventing this matter from happening again. You have to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition, sir, is so you can further increase your understanding of the dangers of driving while under the influence and the consequences of such behavior. Fortunately, there wasn't more serious charges as a result of this. And then the court's going to order 5 days in the court workforce. The rehabilitative goal for that condition is so you can further develop life skills and give back to the community. Any questions regarding those conditions?
No, but August 8th, you know, you could say fiance did, but plan on going to Chicago. That's what do I know can't do that.
Okay, no, not necessarily. So the court will note that you haven't had any violations on your tether.
No.
So the court will permit you, sir, to go to Chicago, so long as you provide those details to probation, okay? And that way, if for some reason your color is called to test while you're gone, then there won't be a violation because you've already communicated all that with probation. You have to just give them dates and specifics. And you said, you can call her your fiance. Is it your fiance or not? Are you engaged?
This is that's what she don't know it's coming with.
Yeah, be careful because it's live streaming, so I wouldn't, so she's not your fiance. She's just your girlfriend.
Yeah, but.
Got it. No, I know. I'm picking up what you're laying down without you laying it down. Okay. All right. So, yes, that's what it says. Notice 27 District Court live streaming all court proceedings.
Hopefully she don't.
Okay, hopefully she's not. Okay.
Thank you.
All right, well, in any event, maybe I'll say you can't go and you have to redo everything. All right, the court's going to order a $300 fine, $100 screening assessment fee, $600 supervision oversight fee, $300 for the cost of prosecution. As to your oversight fee, sir, it's $50 a month at 12 months, and since you're eligible for early discharge, up to half of that could be waived, all right? $75 crime victim assessment fee, $50 justice system assessment fee, $200 for the court workforce, 5 days at $40 a day. So let me just caution you. Whatever you do when you're in Chicago, you cannot consume any alcohol, okay? And before,
I don't drink, I don't smoke.
okay, well, at a 0.187,
Yeah.
and you're still able to figure out how to operate a motor vehicle, you've got some tolerance.
I'm a big guy.
Well, you are, no doubt about that. However, just so you know, I've heard all excuses, even, if your fiance kisses you after drinking a glass of wine, you're gonna test positive. That doesn't even happen. Or it doesn't even, people try to say it happens, but it doesn't happen. All right, so, sir, as I did indicate, you are eligible for early discharge as long as all of the following have occurred. You completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you made good faith effort toward making full payments. Okay?
Thank you.
Good luck to you, sir. You're gonna go over to probation, you're gonna get all of your next steps, and then just communicate with them that I did address that with you. I will make a note here. They may travel to Chicago with details to probation so long as not in violation. Tether can be removed. Okay, good luck to you, sir.
Good luck, sir.
Thank you. All right, I really do like that jacket. Okay. We are on the record in the matter of the city of Wyandotte versus Brianna Reyes, 26635.
And once again, Your Honor, Edward Holmberg, on behalf of the defendant, approaching.
Thank you. And your name, please, for the record. Thank you. Thank you for addressing appropriately for court. Today is the date scheduled in this matter for sentencing on your client's plea to an amended charge of operating while visibly impaired. The original charge of operating while intoxicated was dismissed by way of resolution between counsel. And did you have an opportunity to review the report and recommendation with your client?
I did, Your Honor. There are no errors or admissions. You simply have to follow the recommendations of the probation department this time. We'll do that to be fair.
All right, Ms. Reyes. So you work part-time.
Right now I'm unemployed. I start my down next month.
Oh, okay, well, I guess there's a change. Okay. Where's your new job?
Is in educate and Black Rock, assistant teacher.
Okay, is that full-time?
Yep.
Perfect. Okay, well, that answers the next question I was going to ask as to why you're only working part-time, but, okay. Well, wait, why are you working until you start your new job?
They didn't need me no more. It was just as needed.
Okay.
Restaurant.
Okay. All right, so you are, you're at a high level as well. 180, that's a lot. Okay, if you test right now, what is in your system?
THC.
When's the last time you used it?
Yesterday.
You gave it permissions, you provided a prescription to the court.
Yes, I see that right here, court approved. Yep, very good. Okay. All right, and so, all right, and so the court's going to find that after hearing from counsel, hearing from Ms. Reyes, reviewing the report, the recommendation, the court does find there's reasonable grounds to Department of Sales 769.5. The court also finds the following assignments to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Ms. Reyes and legislative guidelines. The court's going to order 12 months probation. You're eligible for early discharge. I'll go over that shortly. You are not to violate any criminal law of any of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is so that you can further receive assistance in providing coping mechanisms so that you can maintain sobriety and hopefully prevent this matter from happening again. Very stressful days as an assistant teacher, so you're going to have to learn some different coping mechanisms. All right, the court's going to order a victim impact panel. The rehabilitative goal for that condition is to further increase your understanding of the dangers of driving while under the influence and the consequences of such behavior. And then the court's going to also order 5 days on the court workforce. The rehabilitative goal for that condition is so that you can further develop life skills and get back to the community. Any questions regarding those conditions, ma'am?
Why not?
Okay, and so since you've already been testing, you're going to continue to test. You may get a different color, it may be the same, okay? The court's going to order $300 fine, $100 screening assessment fee, supervision oversight fee of $600. It's $50 a month at 12 months. Since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50. Workforce of $200. It's 5 days at $50. It's 5 days at $40 a day, which brings the total to $1,625. So you can set up your payment plan with probation. Do you have any questions regarding any of that, ma'am? As I did state, you're eligible for early discharge as long as all the following have occurred. You completed at least half of your original term of probation. All probation requirements have been completed for at least 3 months without any violations, and all monies have been either paid in full or even if faith offer to making full payment. Okay? All right. Thank you. Have a good day. Thank you. All right, let's go off the record for a moment. Has Miss Posey or has are they lodging with Miss Posey yet? Okay. All right, let's go on the record in the matter of the city of Wyandotte versus Nicholas Stawali, 26645A.
Good afternoon, Your Honor. Attorney David Leffman, Finger 67984. Nicholas Dwally stands to my right. His date stating the rights. Nicholas Dwally.
I don't know if we picked you up, so if you can get a little closer to the microphone, please.
Nicholas Dwally.
All right, thank you. All right, and so today is the date scheduled for sentencing in this matter. And sir, thank you for addressing appropriately for court. And counsel, do you have opportunity to review the report and recommendations with your client?
I have, Your Honor. There's no need to amend it. It's nothing materially incorrect or omission. I did file a sentencing memorandum.
Yes, I did review that.
Mr. Swaley is 49 years old. He's never been in trouble with the justice system before. He's originally from Wyandotte. I know it's in Portage. He was here on that day in question to referee a high school regatta that took Mr. Swaley wrote at Roosevelt. So he comes back twice a year for the Uptick Cup and the Y High. This was an unfortunate incident. He made a bad mistake. There's no doubt about that. He's truly remorseful for his actions. He's thankful he did not only hurt himself, but anyone in the public. I filed the memorandum of sentencing because the state of Michigan considers non-serious misdemeanors to be punishable by fines and maybe service. And they consider OWI or OWVI a non-serious misdemeanor. It's not my opinion. It's the state of Michigan's opinion. I know it's a rebuttable presumption, and most courts rebut that presumption and sentence people charged with found guilty or pled guilty to drinking and driving to probation for good reason. I think this is a case that the court can find its way not rebutting that presumption. Again, Mr. Soar is 49 years old, never been in trouble. He tested category 1 for both drugs and alcohol, meaning that he does not have a substance abuse problem. This truly was a poor choice on his part. I don't have a crystal ball. I can't say for certain that this isn't going to happen again in the future, but I believe, given the fact that he spent 49 years not getting in trouble, he's going to spend the next 49 years not getting in trouble as well. We're just asking to bring some leniency in this matter, given the fact that he does live in Portage. He's an educator. He's been an educator his whole life for 25 years. He gives back to the community already. He knows he's well-versed in community service. We just ask that the court sentence him to costs and funds at this time.
All right. So, sir, obviously you're going through a tough time personally right now. So how are you handling that?
I'm in counseling, with a personal counselor, with the counselor within my school district that assists me through that. I have made sure that it's been, since this day, I've been staying away from don't use drugs at all, staying away from alcohol because I'm ashamed of myself. I'm embarrassed. I have young boys that I'm dreading the day that I have to talk to them about this conversation, and this whole situation. It was being here and having to tell the story about me getting divorced 25 times that people haven't seen in a year and a half. And it was just, felt like I just didn't realize where I was at and how it got out of hand. But yeah, I'm thankful that no one was hurt. I'm thankful that I wasn't hurt. I'm thankful that everybody was safe throughout the situation. And I'm embarrassed and ashamed of myself.
So, one correction I see is that, it says you have 2 children, but I only have the age of one of your children.
I have twins.
Oh, well, that would explain why there's only one age. Okay. All right, so, taking all that into consideration, the court, does agree with the recommendation that, there should be at least one condition that you complete. So in order to ensure that happens, the court's going to rebut the presumption, find that there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Sulawi and the legislative guidelines. The court's going to order 3 months probation. You're eligible for early discharge, which is in a month and a half. So within that month and a half, sir, you'll have to complete the MAD victim impact panel, all right? And then you're not to violate any other law of any unit of government, not to be state without the consent of the court, and notify your probation officer immediately of any change in address or employment status. It's also going to be non-reporting, right? The only thing you have to report is your completion of your program.
Okay.
Any questions regarding that?
Just a clarification, Your Honor. I don't have any, I understand the sentence. The question I have is, to be released early, you have to have 90 days without a violation. And if you're sentenced to 90 days of probation, I don't know that he can be released early.
Well, he can, because it states that so to be eligible for early discharge, which I haven't done the finding cost yet, but to be eligible for early discharge, you have to have completed all the terms of your probation, completed at least half of your original term, not had any violations within 3 months from your requesting of the term of the discharge. So it's just within 3 months, there hasn't been a violation. So if he doesn't have a violation within, what's that?
Does bond phase count then towards that 90 days?
No, it doesn't have to.
Okay.
Because if your client is sentenced to 3 months probation, right? And if one of the requirements is you cannot have had a violation within 3 months. So it's within 3 months. So since everyone's confident he's not going to have a violation, there won't be a violation within the 3 months, within any time before his time to be off.
Understood.
Yes. And so then also, your fines costs have to be paid or make a diligent effort to make a payment, make full payment. Okay. $300 fine, $100 screening assessment fee. I'm going to only charge 1 month of oversight fee just so that there can be a receipt of the, make sure you're doing your victim impact panel and so forth. The cost of prosecution, $300. Crime victim assessment fee of $75. Justice system assessment fee of $50, which is a total of $13.25, I believe. Nope, definitely not $13.25.
I think it's 8. I think it's 9.25. Or 8.
$8.75. Okay, and and I've already gone over my spiel about early discharge. Okay, so sir, I'm just gonna go over to probation, you get information about the Mad Victim Impact Panel. And if you're able to make full payment, you can make full payment, otherwise you can set up a payment plan with probation. All right, good luck to you, sir.
Thank you, Your Honor.
Thank you, have a good day. All right, let's go off the record. Hello,
Hi, Judge, how are you?
good, how are you?
Good. My client made it.
No, sure.
Oh, very good, where is your client?
There.
Oh, I didn't see you over there. All right, see, look at that. Your feet are the fire, you make sure it happens. See how that happens?
Right.
All right. Sometime, you know, where there's a will, there's a way. So there you go. Okay, so let's go on the record in the matter of the state of Michigan versus Dean Dozier, 26533.
Good morning, Your Honor. DeAnna Utility 82378 on behalf of Mr. Dean Dozier. State your name.
Dean Dozier.
All right, thank you. Not only did he show up, he dressed appropriately. All right. So, today is the date scheduled in this matter, for sentencing on your client's plea to an amended charge of financial transaction device fraudulent withdrawals, transfers 200 to 1,000. And is Christine Dozier here?
Yes.
Okay, so I will give her an opportunity to address the court and counsel.
So, Your Honor, we did review the report. There are no additions, deletions, or corrections, other than my name has one N in it. They put two N's. But other than that, there are no other additions.
I'm gonna make sure they know that that's not it. All right. Okay, and so, council asks for the recommendation.
So, Your Honor, I respectfully disagree with the recommendation. I don't mean to be difficult, but I was kind of hoping that was a typo. I'm not seeing a probation department recommend jail for a criminal history that's almost 18 years ago. I understand there is something in 2024, disorderly conduct. But I don't know that Mr. Dozier should be sentenced to jail for a criminal history almost 20 years ago, dating back that far. During the time that criminal history was created, Mr. Dozier, he was in a tumultuous marriage. He had substance abuse issues at that time. Mr. Dozier does not have any substance abuse issues now. He has been so clean and sober for over 2 years. And, you know, it's unfortunate, but the marriage did end. So I do believe he would be able to complete a probation. So I would ask if the court would maybe ignore the probation's department recommendation for jail and just notice that Mr. Dozier, I think that he is a good candidate for probation. I think that he would complete the probation. The only issue that he does have is that he does reside in Lenawee County now. So I don't know if the reporting could be over Zoom if the court does order probation. But other than that, he's been doing really good. He's been staying out of trouble. I mean, he's looking for work, Your Honor. So he's trying to stay on the right path. Okay, he's also disabled, so he's looking for Social Security disability. So I would ask if the court would put Mr. Dozier on probation, along with the fines and costs that will come with that. Thank you, Judge.
All right, thank you. Okay, Ms. Dozier, would you like to address the court? All right, I'm going to ask you to please state and spell your first and last names for the record, please.
Christine, Christine, Dozier, Dozier.
Okay, very good, thank you. And would you like to address the court does appreciate you coming in to address the court. And what would you like the court to know?
I just like for Mr. Dozier to be responsible for his actions. It was a total of $3,500 that he had stolen from me. And I just don't believe that's right to do from his ex-wife. I am his daughter's mother. let alone to a stranger, $3,500 without permission. So I just want him to, whatever he believes is right for him, for some kind of punishment. That's not $3,500, that's all the way I had for my daughter, to take care of my daughter.
Okay, so do you have the bank statements or otherwise?
I didn't bring anything with me, no.
Okay,
But I wasn't gonna say a statement at all, but since I'm here, I will.
okay. And are you able to obtain those documents so that if for some reason they are contesting that that's $3,500, you could submit that to probation?
Yes, I could not find my paperwork for that way. Last night when I looked through my paper, I had court papers, social security papers, I could not find it last night.
Okay, was it from a bank card or was it
Yeah,
a credit
Or
card?
debit card, he took, yeah.
Okay, so you could get that information from your bank?
I could, yeah.
Okay.
Or from the police report, because he went to jail.
Right, but sometimes you might, unless the police report has the actual bank statements with it, you may have to get that. There may not be an objection to the amount of restitution, I don't know.
I got the money back from Chase.
Oh, you did get the money
But
back?
I just don't think he have to be responsible for the money that he took from me. But I did get my money back from Chase, yes.
Okay. Okay, and there's currently a no contact order, is that correct?
I have not heard from Chase, but he hasn't contacted my daughter or myself anyways, so
Okay, how old is the daughter the two of you share?
17.
Yeah, so there's no contact with you, ma'am, that's, and not to return to the home on Goddard Road. As it relates to your daughter, I don't believe that the court did not restrict communication with your daughter.
So we do have visitation, but he just hasn't done it in a couple of years now.
Oh, a couple years, okay. How, did you give Mr. Dozier your card, or how did he end up with your card?
I did not. That I don't know. My daughter had surgery, blah, blah, and him and his girlfriend had split up. So we were kind of talking about getting back together, and I told him I had changed my mind, I didn't want to get back together, so he did stay the night at my house, and we spent the weekend together. I had my credit card on Sunday night, we went to Walmart's. Monday, I just happened to pay a bill online, I looked on my bank statement, and it said $890 at McKinsey's garage. And I went up there, and he was there with my credit card, and he spent $2,300 at the phone place, $400 on like 2 different bank transitions, and more money at a gas station. So it totaled up to like $3,500. So I did not give him permission.
Okay. All right, and you have been made whole, correct?
I'm sorry?
You've been made whole by Chase Bank?
Yes.
Okay,
I canceled out of Chase and I'll go to Huntington since that happened.
okay. All right, thank you very much for coming in.
Thank you.
All right, and, counsel?
So, Your Honor, as to the money, I know he's already pled, but there were stop payments put on what was done. The vehicle was actually in both of their names. I'm not sure what happened with all that, but they both have different allegations. Mr. Dozier would object to restitution because it is, I believe, and I don't have it with me, I don't want to speak, but I believe it's in the police report that there was stop payments put on, there were some phones, so.
Right, and she did indicate that she received money back, she received everything back from Chase, so she wasn't out of pocket the money.
Correct, right?
Yes.
And as you stated, Mr. Dozier has not had any contact with her, but she has been constantly trying to contact Mr. Dozier along with Mr. Dozier's girlfriend on a regular basis. And even when we were in court, she was still in the parking lot waiting for Mr. Dozier to come out. So I don't want Mr. Dozier to be violated. That is the reason why I'm putting this on the record, and I want the court to be aware he has not tried to contact the complaining witness. He doesn't want contact with the complaining witness. It's her that's trying to contact him. So I just wanted the court to be aware. But again, I still would ask that Mr. Dozier be placed on probation. The very good deal, Judge. Thank you.
All right, thank you. So Mr. Dozier. Are you on probation or parole anywhere?
No, ma'am.
What happened with your matter in Lenawee County in 2024?
Disturbing the peace, and I was on probation, and I got off early for completing everything.
All right, and did that involve your fiance?
No.
All right. So, sir, it appears as though the relationship with Ms. Dozier is done and over. There's really no reason for any contact.
She's been contacting me with my fiance.
And that's what your attorney stated, sir. Well, now she hears that there's not any contact, so the court's going to make sure that there's a reiteration of no contact. So whether she's contacting you or not, I don't know. But the court will note that probation did make a recommendation for incarceration. The court also will note that there was a sentence agreement of sorts with between the prosecuting attorney and Ms. Patillo for 1 year probation, no early release, better decision-making class, and any additional terms set by the court, as well as full restitution if applicable. So based upon that, the court's going to find that there's reasonable grounds to depart from MCL 769.5. The court's going to find the following sentence is in the best interest of justice, is reasonable proportion to the seriousness of the matter, taking into account the circumstances surrounding Ms. Dozier and the legislative guidelines. The court's going to order 12 months probation. You're not eligible for a release per the plea agreement. You are not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer. As often as your probation officer may require, whether in person, writing, or virtually. Most of your clients' meetings, counsel, if not all of them, will likely be virtual since he's a bit of a distance. The court's going to order no contact with Ms. Dozier. Since your child is 17, your child is a fully functioning 17-year-old, correct?
Yes, ma'am.
Okay, there can be any communications that is desired between you and your child can be amongst the two, just between you and your child. Not to return to the home on Goddard Street where Ms. Dozier resides. Nor her place of employment. You're to participate in economic crime class, the rehabilitative goal for that condition, so you can fully understand all the consequences of and impacts of choices of involving financial transaction devices or otherwise. The court's not going to order restitution. As Ms. Dozier stated that she is not out of pocket any money. Chase Bank decides they want to pursue something, then that's up to them. The court's going to also order making decisions class, rehabilitative goal for that condition, and so you can further understand the importance of making appropriate decisions so that you don't reoffend. Okay.
He's seeing a therapist and a psychiatrist. I believe it's in the pre-sentence report.
Yes, right, very good. All right, and the court's going to order a $400 fine, $100 screening assessment fee, $600 supervision oversight fee, that's $50 a month, at 12 months, and since you're not eligible for early discharge, all of that money will be due. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, which is a total of $1,425. Is Ms. Powell your fiance's name?
Yes.
Okay, so she did post a bond. I don't know if she signed anything to apply it over to fines and costs. If she did, then we can proceed that way. If she did not, and she intends to, she'll just have to sign a document.
No, she posted the bond. She did.
I know she posted the bond, but if she wants to apply the bond to fines and costs, that's okay. And so then you can set up a payment plan for the balance with probation.
No, she can get, quiet or come pick it up down here, or go down to Wayne County.
If she wants to apply it, there's a document she has to complete here.
Okay.
If she wants it to not be applied, then what happens is it gets mailed back to her
Oh, okay.
directly.
Okay.
Okay. All right. Any questions?
No, Your Honor.
Okay.
Well, Your Honor, I want to say that, I live in Wayne County, and there's no way I can get down here. I have no
The
cars.
judge already said you can report virtually.
Oh, I didn't hear. I'm hard of hearing, so, I didn't hear. So,
Yes.
Thank you, Judge.
You're welcome. All right. Good luck to you, sir. Thank you for making the effort to be here.
Thank you.
You're welcome. Okay, let's go off the record. Okay, well, Ms. Ruprecht, we're gonna find out, if they've logged in, if they've even responded. We've notified them about logging in with Ms. Posey.
Thank you, Judge. I just did the same. I hope the court is more successful.
Okay, thank you.
They're here for the Paris exam, two sitting in the back there.
Okay.
It's really.
I'm ready.
Is that what we're doing?
I think so.
Okay. Just wondered.
Yeah, my client's here, we're ready to go.
Okay.
All right, so council, let's see, and then we have, is Mr. Dubin here?
No, he wasn't. I don't, since I went back in there, I don't know. I thought I saw him earlier.
Okay, so, all right, that's everybody. Everybody's appeared today. Except for Angel Flores. All right. Okay, I'm gonna step off the bench for just a moment. Mr. Ali, we're just waiting for your attorney to get here.
Okay, Your Honor. Thank you.
Hoping that
Malcolm on the Zoom, can you hear me?
Yes.
Hi, good afternoon.
Do have to get done? Do we get paperwork? Do they have to get done? Do we get paperwork? I need to get from the one.
Malcolm Gilmer on the Zoom, what banner are you here for?
Oh, you got paperwork on?
Just.
you back into the courtroom. All right, then mute yourself until they're ready.
This time I actually sent them like a formal thing.
I know, it says case.
Okay, all right, Mr. Or where's Miss,
They're in the back right now with our one in custody.
okay,
All right,
Yes.
here comes Mr. Dubin.
okay. Hi, Mr. Newman. Hi, Ms. Cozy.
The prosecutor said,
What's that?
I've been here on.
I don't want him to see my car.
Okay, Mr. Mohammed, if you want to stay muted, please.
I take it down as soon as I get in. A mystery machine.
I'll mute myself then, okay. Okay, what was that?
Ms. Ruprecht let me know they're gonna waive, but
Okay.
he's still got the file for that, so.
Okay, Mr. Mohammed, can you please bring in the Ruprecht file, or the Posey file, please? And then, we're gonna handle that, then we're gonna handle Mr. Dubin's matters. We have an in custody we have to do, and then we're gonna do the exam.
Mr. Dubin,
Okay, so then while we're waiting for the file then for that, Allie's out in here. Okay.
thought he was. So,
Ms. Smith's done.
okay.
Sorry, I didn't hear.
Elevator.
Mr. Snow.
Okay.
Okay, so Mr. Mohammed, just so you are aware, just like the order that we're doing things, so you know when to be ready for the exam, the Carlos Harris exam, we have, I understand Ms. Posey's gonna wait, and then we have Mr. Dubin's 3, we have 1 in custody, and then we have the exam. So we'll likely start the exam within like the next 10, 15 minutes. Okay, Mr. Rivera?
Yeah, you're on.
Thank you.
Mr. Mohammed? Okay, you're welcome.
Okay.
Okay. All right, Alan, ready? Okay. All right, let's go on the record in the matter of the state of Michigan versus Jared Wallen, 26587. Wait, what's that?
I think the lease is switched the thing.
Oh, hold on, let's go, hold on, just one moment.
Should I need a tie?
Yep, and everyone come up here, hold on, let's go, hold on, one second. Mr. Gopal, hey, look, very nice, even everything coming together. Did you give him the ties?
Yeah, right. I just want to make sure.
Yeah, he does have ties. He even has 2 options for a tie.
Okay.
I had some hanging in my, right.
Okay.
Yeah,
I'll get that, I'm ready.
all right. And let's go on the record in the matter of State of Michigan versus Jared Wallen, 26587. Counsel, your appearance, please.
Your Honor, you as your staff attorney, myself, be with P number 8609, on behalf of Ashley Vaughn, standing for the Torah, please take your pen, Judge.
Jared Wallen.
All right, thank you. And so today thank you for dressing appropriately for court as well, sir. Today is a date scheduled in this matter for the
First pre-trial.
for the pretrial. No, it's not the first pretrial. There was arraignment pretrial May 21st. And then the pretrial was held that day. Then it was requested to adjourn to June 18th. And so we adjourned it to today's date. And now you're asking for another adjournment.
Correct, Your Honor. I now have all the body cam and the discovery on it. I was dealing with body cam thing. There are some issues in this case, where I do think it requires another, without giving too much of the facts of the case away. There are some issues I see with this, and, I do believe we can come to a resolution, but I think it's gonna take a little more, Your Honor, if I'm being quite honest.
Well, when you say it's gonna take a little bit more, what is it you're meaning?
Well, I do, want to get specific about it on the record.
Well, I'm just asking, are you saying that it's going to, need another 2 months? Are you saying it's going to?
No, not at all. Another 2 weeks would be perfectly fine. It's just, I think there's been offers made and my client is aware of those offers. However, there are other factors now that I have everything that would warrant maybe even a different offer. And I think the prosecution understands that. So that's kind of where we're at.
Okay.
May need to get a supervisor involved, may not.
All right. Looks great. Okay, so, well, we don't have a docket in 2 weeks, council, so we can move it to the 13th or the 20th. Which has less cases, the 13th or the 20th?
I'll take whichever one has less cases.
Oh, I'm sorry, it'd be the 21st. I did confirm 28th is covering our state docket that week. So we could do the 21st.
No problem. I just want to make sure too, Your Honor, because I only have, because I've only been here the 18th and this is my second time in court here.
Well, it's possible, you probably had, a MIDC attorney for the first one.
Yeah, I just want to only think I'm kicking the can out of it. It's my own personal thing.
Okay. All right.
You guys are very gracious with me, so I want to make sure I keep that going.
All right, so let's do August 21st. Okay, that's 9 AM right now. At 9 o'clock in the morning. That's at the 28th District Court.
27.
Nope, 28th.
Oh,
She's covering my docket then.
Oh, Judge Mullins is?
Yes.
Oh, cool. I haven't been there.
Yeah, okay, and I think the other one we moved to that date, I did not write, 28th District Court in the hour way. Thank you very much. All right, sir, if you're to test right now, what is in your system?
Nothing.
All right, bond and conditions are continued.
That was good.
All right, have a good day. All right, and we are on the record in the matter of the State of Michigan versus Michelle Henderson, 26424.
Good. Your Honor, to you, Andrew Staff, and Senator Maxwell, to VP number 02, on behalf of Ms. Henderson, who stands to my right, please state your name for the record.
Michelle Henderson.
All right, good afternoon, and today is the date scheduled for the adjourned probable cause conference in council.
Your Honor, we're just asking this matter to be set for example. Any date works. Again, I have talked to the with the APA and the supervisor, and this, if there is a resolution short of exam, I will let them know, so no officers are called, which I think there might be.
All right, this has been pending for a bit, so let's forward on next week, July 30th.
July 30th, no problem. Afternoon.
Well, we'll tell you, I think the afternoon's getting full.
Okay.
But I'll let you know here in just a short bit.
Um, 11:30.
All right, does 11:30 work, council?
Works for me.
All right, any witness exhibit list by July 27th, ma'am? If you're to test right now, what is in your system?
Nothing at all, ma'am.
All right, bond and conditions are continued. We'll see you back next week. Thank you. Have a good day. And we are on the record in the matter of the State of Michigan versus Ibrahim Ali. Hold on, let's go. Let's go off the record. Mr. Mohammed?
I will get him.
Okay.
Let me go grab him.
He might be listening.
Yes, please.
We show my face back.
Um, okay, you know what, counsel, Mr. Mohammed, I'm gonna speak to you, and Mr. Dubin, in chambers in just one moment. Let me, did you, because Ally emailed you on this, right, with how to contact the victim in here in this matter?
She just advised me that the victim is being treated by the Wayne County Jail. There was no contact information, but
Right,
my office,
it was so that you contact Wayne County Jail to find out which treatment facility she's in.
so my office did take steps to attempt to make contact with the victim. I'm happy to put everything on the record. I think there was
Since July 16th,
yes.
through the Wayne County Jail?
There's been attempts by my office to make contact with the victim. But we've been unsuccessful at this time. I personally performed, again, I'm happy to put up.
Well, we're not on the record, but we'll talk about this in chambers in just a moment. We handle these other matters. Let's go on the record, or actually, I mean, Ms. Rubrick. Is she, where'd Ms. Rubrick go?
Not sure where she is. Like the crowd.
Okay, and we are going on the record in the matter of the state of Michigan versus Danielle Posey, 26878. And counsel?
Good morning, Judge Aaron Ruprecht, Neighborhood Defender Service, P8778, here on behalf of Ms. Posey, who's presently Zoom. Ms. Posey, could you state your name for the record?
Danielle Posey.
All right, good afternoon. And today is the date scheduled for the preliminary examination, and counsel, you did have an opportunity to speak to your client in a breakout room virtually, correct?
I did, Your Honor, and I did have an opportunity to advise Ms. Posey of her right to hold a preliminary examination. And having been informed of that right, she is prepared to waive it today.
Okay, and counsel, I'm sorry, what is your P number?
It is 87978.
Okay, thank you. Is it Ruprecht or Ruprecht? Ruprecht with a P, okay. All right, so ma'am, you heard the, what your attorney stated on the record, correct?
Yes.
All right, did you understand that you do have the right to have a preliminary examination in this matter? Mr. Mohammed, I need you to sign this as well as the attorney. You do have the right to have a preliminary examination in this matter, and by waiving your right to a preliminary examination, you will not have that.
Yes.
And you also understand by waiving your right to preliminary examination, you will be bound over to circuit court for further proceedings on the charges in the complaint warrant. Do you understand that?
Yes.
And you have in fact received notice of those charges in the complaint warrant, correct?
Yes.
Right. And has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to a preliminary examination?
No.
Okay, and counsel, Mr. Mohammed, did you sign the document?
I'm waiting for counsel to finish the moments.
Ms. Posey, I do have a form in front of me that basically outlines everything the judge just said. Do I have permission to sign on your behalf as your attorney?
Yes.
Thank you.
All right, the court will, then find that, we'll note that upon signature, defendant is waiving her preliminary examination. The court will, note that this matter will be bound over circuit court for further proceedings. You are to appear in circuit court on July 30th at 9 o'clock in the morning at the Third Circuit Court. And counsel, it will likely, I presume, be via Zoom since your client's in treatment.
Yes, Your Honor.
All right, bond and conditions are continued. How are you feeling, ma'am? I know you just got there. How are you feeling?
I'm fine.
Okay, all right, good luck to you.
Thank you.
You're welcome. Yeah.
Thank you, Judge.
Bye.
Thank you, Aaron. Call me.
I will talk to you soon.
Okay.
All right, and then let's go on the record. In the matter of the state of Michigan was Devin Hinton, 261064. And Sergeant, if you can please unmute and state your name for the record, please. Nope, you're still muted.
Yeah, there you go. No trouble.
Sergeant Stephen O'Warren.
All right, thank you. And please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, you may proceed on the warrant.
On July 23rd, 2026, at approximately 12:43 in the morning, Officer Saltzman was patrolling southbound Fort near Pine when he observed a tan Dodge Durango with Michigan registration of EVF 3714 that was weaving heavily in its own lane of travel. As Officer Saltzman continued to follow the vehicle, he observed the driver swerve to the left, crossing the dashed white lane line, then swerved back into its lane of travel. Officer Saltzman activated his overhead emergency lights and conducted a traffic stop on southbound Fort near Quarry. Upon making contact with the driver, Devin Hinton, Officer Saltzman informed him why he was being stopped. He then asked Hinton for his driver's license, and he stated he did not have one. Officer Saltzman asked Hinton if he had a valid driver's license. He stated he did not. It was suspended. Officer Saltzman observed Hinton's eyes to be bloodshot and glossy, and he detected a strong odor of intoxicants coming from his person. Officer Saltzman asked Hinton where he was coming from, and he stated Riverview. Officer Saltzman told Hinton he was currently heading into Riverview, to which he then stated he went to get cigarettes and was going back home. Officer Saltzman asked Hinton how much alcohol he had to drink tonight, and he stated 1 beer, and it was about 3 hours ago. At this point, Officer Saltzman had Hinton exit his vehicle to perform standardized field sobriety tests. After performing the SFSTs, Officer Saltzman read Hinton his preliminary breath test rights, and he initially refused, but then finally agreed to test and produced a sample of 0.18% BAC. Hinton was placed under arrest for operating while intoxicated. Hinton was checked through lean, and it revealed that his license was revoked with 2 prior OWI convictions. The first conviction was back in March of 2009 out of Ypsilanti, and the second back in December of 2013 out of Romulus. Lean also indicated that he needed an interlock device to operate a vehicle, which this vehicle was not equipped. Officer Saltzman then read Hinton his chemical test rights verbatim from the DI 177 form. He refused to take the blood test by not answering the questions. A blood draw search warrant was completed and signed by yourself. Hinton was transported to Henry Ford Wyandotte Hospital, where RN Bukowski drew 2 vials of blood from his right arm. The kit was then sealed and later placed in an outgoing mailbox, and was transported back to the Wyandotte police station where he was held.
Upon examination of any witness, the court does find the probable cause that the offense charge was committed. There's probable cause to believe defendant committed that offense. Counsel, your appearance, please.
Your Honor, John Goldpaw, P 30758, on behalf of Mr. Hinton. Mr. Hinton, please put your name on the record.
Devin Hinton.
Great, thank you, good afternoon.
Thank you. As to the arraignment, Mr. Hint would stand to charges, mute to charges, waive a formal reading of those charges, ask for a plea of not guilty be entered on his behalf.
All right, the court will waive the formal reading, so you do have the right to have an attorney. If you're unable to afford one, then you may ask for one to be appointed to represent you. You did, in fact, have an opportunity to speak with an attorney today, is that correct?
Yes.
All right, the court is also signing the appointed attorney form for felony matters. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
The court's going to enter a plea of not guilty in this matter. Schedule this matter for probable cause conference.
July 30th at 8:45.
July 30th at 8:45 a.m. Counsel as to bond.
Your Honor, as to bond, Mr. Hinton is 41 years old. He is self-employed. He and his fiance own a business which does custom cars, redoing interiors, etc. She and he are the sole employees and owners of that business. As I've indicated, he's 41 years old. He is not on probation. He is not on parole at this time. He did have some prior contacts with the criminal justice system. However, you're at, of course, the two drinking and driving offenses, which are also referenced. He is gainfully employed, and again, he's not on probation or parole. Your Honor, at this time, we're asking for a bond commensurate with the charges. We would hope that somewhere in the area of 5,000, 10% with an alcohol tether would be approved by this court.
Well, sir, how long have you had this business?
I've been operating for 20 plus years. It initially started off as a side business within the current employment that I actually had, and I actually went on and licensed it.
Okay, and so who lives at the home with you, sir?
Me, my fiance, and our children.
How many children, sir?
In home, it would be a total of 7.
Do you have children that are not at home?
Yes, my older children from my previous divorce.
Okay, so how many children total do you have, sir?
On my behalf, it would be 7. We have a blended family, so she has 4 children that aren't within blood relation to me.
Okay, I understand that. Thank you. All right. And have you ever failed to appear in court for any reason, sir?
No, ma'am.
Are you on probation or parole anywhere?
No.
And Sergeant, would you like to address bond?
Your Honor, this is once a felony offense, 3rd offense. He's driving without a license. There's a hazard to the community with him driving around with no license and driving intoxicated. Who knows how many times he's done this prior to this before getting caught. 15,000, 10% with the tether is what I'm looking at, please.
The court does have concern for the safety of the public, significant concern. Number one, as this court has before, Mr. Hinton does not have a valid driver's license, so he shouldn't even be behind the wheel of a car at all. Second of all, given the allegations in this matter, and that it's alleged that Mr. Hinton not only had a blood alcohol level, but a high blood alcohol level, and this is a 3rd offense notice, the court is concerned for the safety of the public. The court's going to order a $10,000, 10% bond with the following bond conditions. Mr. Hinton, you are not to possess or consume any alcohol or drugs unless prescribed. You are not to operate a motor vehicle without a license, without a valid license. And you are not to be released without an alcohol tether from the Wayne County Jail. Thank you. Good luck to you. Have a good day. Okay, let's go off the record. If I can please see the attorneys on, Mr. Ali. What's that?
Yeah. When you take a picture, I just love this outfit. I think
It looks fantastic. It all just came together.
I just
Okay, and we are on the record in the matter of the state of Michigan versus Ibrahim Ali, 26464.
Good afternoon, Your Honor. Mohammed on behalf of the people.
And good afternoon, Your Honor, Attorney Maxwell, P number 86012 on behalf of Mr. Ali, who appears in the Zoom.
Mr. Ali, please unmute and state your name for the record, please.
Your Honor, Ibrahim Ali.
All right, and good afternoon. I appreciate your patience today and thank you for addressing appropriately, especially since you're on Zoom. And so,
Thank you so
counsel,
much.
we did have a conversation in chambers with both the prosecution and yourself, correct, counsel? Are you on the phone for this matter?
Yes, Your Honor, that's okay. I was just getting in my calendar, but yes, that is correct, Your Honor.
All right, and so after discussions in that regard, the court is, because the victim in this matter, well, one of the victims, the other one's Family Dollar, but the non-commercial victim was located as to where she can be contacted, and so there is a process by which that's going to occur. So as such, the court finds it prudent that we'll adjourn this to July 30th. My boss is going to give me the time.
11:30.
At 11:30 a.m.
Is that in South Korea? Is that here?
No, that's here.
That's here. Okay, so August 21st is in South Korea?
Yes, that's a Friday. So it's a Thursday, it's here. It's a Friday, it's 28th.
I got them confused. That's why I'm not.
Okay. All right, and then counsel, we did indicate we would revisit the tether issue at the next court date, which is today. And so, counsel?
Your Honor, yeah, I'm just asking that this court consider removing the tether. Obviously, we are waiting here to put a plea on the record. That being said, client has appeared at every court date. He's been in constant communication for me. The tether is starting to interfere with it. It is starting to become costly. I would ask this court consider just removing the tether, keep all other conditions on bond as my client has shown and demonstrated to this court that he can abide by any of your rules. Anything you ask of him, he will do. We're just asking that the tether be removed for those reasons, Your Honor.
All right, Mr. Mohammed?
Your Honor, I'll defer to the court's discretion.
Okay, and you placed your appearance on the record already, correct?
Yes, he did.
Yes, that's what I thought. Okay. All right, the court will note that this matter is being adjourned one more time. The court will note as well that it did indicate it would revisit the issue of the tether removal today. And there not having been any violations while Mr. Ali is out on bond, albeit that Mr. Ali is currently on federal probation, correct, sir?
Yes.
Yes. The court will grant that request to remove the tether. So, sir, you're going to have to email into probation, or Mr. Dubin, maybe you can go over to probation. You can facilitate how that happens.
Perfect. Thank you, Your Honor. I'll see you guys July 30th.
Okay, thank you. Have a good day.
See you as always.
All right.
Thank you,
All
Your
right,
Honor.
let's go. Have a good day, sir.
You too. Have a wonderful day. Thank you so much.
30, on the 30th, 9 a.m.
I thought you were putting it in your calendar as we were on the record.
That's what I do, but I get distracted. So I go 9 a.m. Okay, 9 a.m. No,
No.
11:30.
11:30 a.m. on the 30th. Come on, man.
Thank you.
Thanks, Scott.
Then I'm calling you back again. It's stall. Stop. Still. You can log off, Mr. Ali.
Thank you, guys. Have a wonderful day.
Well, to me, I wish to see.
All right.
Oh, a teddy rubber band. So Natalie did, yeah. So she's got.
Okay. So I did not sign this one for Mr. Campbell because it has to be Okay, so, Jim, the file, do we have the file?
Good. Did you have that file?
I don't know. I'll check.
Leave it at least.
I don't, moving forward, do we need to have the exam files?
Well,
Is that not really gonna?
if you end up having a resolution, then you would have to have the file for, to put a plea on there.
Okay, yeah, that makes sense. But usually if we're not gonna resolve them at the PCC, is it resolved at the exam, but
Well, that's not accurate. Look at you on Mr. Dubin's case. No, that was being resolved, yeah,
That's okay.
anyway. But there's been oftentimes that that's happened, so we're sticking with the same process.
Well, let's get to that, some of the comments. Got it, probation.
Others need some for the county.
Okay,
Is it still, these, you gotta sign them first.
but I did sign, I just did this.
There's that file.
Okay, thank you. Okay, so. Okay, is that? Okay. So this is the old one, so that would need to get rid of, that's the.
So this is.
Same with this one.
Yeah.
This one can also be with them, but so I signed that one, but I don't know if there needs to be two. Okay, so let's go on the record in the matter of the state of Michigan versus Carlos Harris. I always say Calvin Harris. I'm so very sorry. 26943. And appearance for the people, please.
good afternoon, Your Honor, Mohammed on behalf of the people.
And good afternoon to your honor and to your staff. Neighborhood Defender Service by Martha Bridgeway, P88847, on behalf of Mr. Harris, who's standing to my right, stating.
Carlos Harris.
All right, thank you. Today is the date scheduled for the preliminary examination, Ms. Miller, and are the people ready to proceed?
Your Honor, at this time, the people are staying a 1 week adjournment. The complaining witness in this case, Crystal Hoach, has refused to cooperate with prosecution. Detective Haskin did make contact with her. He attempted to serve her with a subpoena for today's preliminary exam. At that time, she refused to take the subpoena or sign receipt of that. Therefore, she was not provided a copy of her subpoena. However, Detective Haskin, prior to that date, had already advised Ms. Hoach of the exam date and time by phone. She stated multiple times to him that she wanted the case to be dismissed. And at that time, that was the understanding, is that she did not want to prosecute, she did not want to assist with prosecution. The secondary witness, Detective Officer Beeble, had made contact with her at the time of the report of this incident, and he is currently out of town. So I anticipate attempting to proceed under MCL 768.27C using statements that were provided to him by the complaining witness, the victim in this case. But again, he's not present today due to being out of town. So I respectfully request a 1 week adjournment so that he can appear and we can proceed through his testimony. He did make observations to signs of injuries of the victim in this case. He had a conversation with her on the same day in question. She had responded to a police department and made a statement to him. And so I'd be relying largely on the statements made by the victim to the officer on that day, as well as his observations to any injuries he observed.
Okay, and when did you receive information that Officer Diebold was not available today?
So Judge, I learned that on Tuesday at 8:30 in the morning. I was in another court in the 34th District Court in Romulus. Additionally, I did not know with certainty whether or not the victim was going to appear or not appear today. As you know, Judge, victims of domestic violence cases can usually change their mind. Sometimes there's reasons for things that are not known to the prosecution. I was hopeful that she would appear today, but she's failed to appear. And in light of the circumstances surrounding this case, as well as the alleged facts in this case and the history between the victim and the defendant, I'm respectfully requesting 1 week to proceed or attempt to proceed using the testimony of the officer in this case.
All right, in your response, counsel.
Your Honor, I absolutely object to any adjournment in this case. I think it is extremely clear from the body cam of, I believe it was Detective Haskin who went to serve the subpoena, excuse me, on Ms. Hosch at her workplace. She said, I don't want to take that. I've changed my mind. That's within my right to do. She doesn't take the subpoena. She doesn't want anything to do with it. The government has stated that they knew since 8:30 a.m. that the main witness in this case, 8:30 a.m. Tuesday, that the main witness that they need in this case was out of town. The first I heard about it is when I showed up today at 2 o'clock for this exam. It's very clear that the complaining witness doesn't want this case to proceed. I have some serious concerns about the government's ability to get these statements out because I don't believe all the requirements of 76827C could be met without her testimony here. And so my position is I'm moving to dismiss this case because there's no complaining witness here to testify. We had this exam scheduled. She knew the date. The officer knew the date. Yes, he's out of town, but diligence needs to be done when we're handling a criminal matter like this. And him being out of town and us just hearing about it for the first time today is not proper. And that is my position. So we're moving to dismiss at this time.
Okay, so I will note that this matter was scheduled last week for exam today. There was not a waiver of time. And so it was scheduled for today. The court did hear Mr. Mohammed state that he was hopeful that the complaining witness was going to appear today and therefore didn't find it necessary to inform anybody that another witness wasn't available.
So, Judge.
But what?
So that's not that part of. I was hopeful that she would be here, but that's not why I didn't notify the court that she wasn't going to be here. That's not really something that I think is common practice. If a witness has informed the prosecution that they don't anticipate on appearing, that we reach out to the court to let them know that, hey, this witness doesn't want to appear. It was
counsel. First of all, you interrupted me when I was speaking. Second of all, you stated that you knew as of Tuesday at 8:30 a.m. that the officer Diebold wasn't available. That's what I'm referencing.
Correct.
Correct.
And the complaining witness. We learned that she did not want to cooperate at that time on Tuesday at around 8:30 a.m. That the officer.
Please stand up when you're addressing the court, please.
Yes, that the officer and the complaining witness both did not want to, well, the officer was out of town and the complaining witness did not want to assist the prosecution. There was a message sent to me at around 8:30 in the morning. I think it was 8:26 a.m. specifically. And at that time, I was assigned to another court and here we are.
Okay, I didn't know that you knew on Tuesday that the complaining witness didn't want to proceed. I thought it was only Officer Diebold wasn't available.
No, we were notified that the complaining witness felt that she did not want to assist the prosecution or cooperate with a subpoena. She refused to sign receipt of the subpoena.
Right, but then you also said you were hopeful she would have changed her mind and appeared here on Thursday.
Correct.
Right, that's what I said. I said the prosecution was hopeful the witness was going to appear today.
That is correct.
Right, and then you interjected and wanted
my
to correct the
apologies.
record. But that's what I stated.
My apologies.
And we won't know until we have Officer Diebold here as to whether or not the statement will be admissible under MCL 768.27C. Because there obviously will have to be voir dire by both prosecution and defense to determine whether or not all of the requirements of that are present for that to be admissible. Given that this is the first request for an adjournment and that Officer Diebold is a necessary witness and he is unavailable due to not being in the area, the court does find there's good cause to grant the adjournment for 1 week.
Thank you, Judge.
Your Honor, may I just briefly, just add something to my record?
Just 1 moment, please. Okay, and what time Thursday next week?
$12.
12 p.m. Okay, what did you want to add for the record?
Your Honor, I just want to briefly add, I don't believe that lack of diligence and preparation on the part of the government is a good cause for an adjournment in this matter. I do believe that the prosecutor stated he knew before Tuesday because Detective Haskian tried to serve a subpoena Tuesday, but also had phone conversations with the complaining witness before that where she had said she doesn't want to prosecute, she doesn't want to proceed with this. And then I think the last ditch effort was this Tuesday attempt of the subpoena serve where she states, again, I've seen the body worn camera. I told you guys on the phone, I don't want anything to do with this. I'll also just note that Mr. Harris is absolutely going to be prejudiced by any adjournment. He's on restrictive bond conditions. He has a tether. He's paid cash to be able to stay out of jail. He's not able to freely move around the city that he works in because of some of these restrictive bond conditions. So it is going to be prejudicing him. And I just wanted to make that clear.
Okay, thank you.
And Judge, I don't have the exact timestamp of exactly when, I'm in court Monday, I'm in court Tuesday, so there's emails sometimes that I miss. It's very possible I received an email Monday, but I can identify as of this exact moment is a text message sent to me on 8/26 on Tuesday, and I'm happy to show that to anyone here, where the officers stating that I sent an email about the Riverview Police Department Carlos Harris case. Looks like we aren't getting reporting officer or the victim on Thursday. Again, I have countless number of courts that I'm assigned to and messages that I get. This is what I received on Tuesday. I'm in court. There was no intention on trying to hide this from anybody. This was 2 days ago. It's just the situation that we have before us. If the victim was here, we would have been happy to proceed. There's been no intention by us to hide the ball or to deceive anyone. It's just one of those situations. There's a lot of moving parts with criminal cases and victims and whether they want to cooperate. Sometimes they want to one day, sometimes they don't the next. So it's not anything that we're trying to hide. Or as soon as the police officers' attempts to serve the victim in this case were captured on body-worn camera, it was uploaded to evidence.com. I immediately followed up my previous evidence.com share to defense counsel and sent her that video that captured that incident. We operate in the light. We want them to see and know everything. If she wants me to go through all my emails in the last week and see exactly, I'm happy to do that.
Counsel, no, that's not necessary. And I don't find that there's been a lack of diligence or effort in that regard. And I also don't find that Mr. Harris is prejudiced at this point with a 1 week adjournment. but counsel, you meet your record, and so that's the finding of the court. So the court will order bond and conditions are continued, and we'll see everybody back next Thursday.
Thank you.
All right, let's go off the record.
Oh, wait, I'm so sorry.
Oh,
Another.
hold on. Okay, Mr. Mohammed, Ms. Ridgway would like to go on the record.
So there's another case, Your Honor. I have a client whose last name is Mr. Alward, Alward. He took a plea last week to a misdemeanor, and sentencing was set to end of September, and he's being held on bond throughout the time. I guess I'm wondering.
In custody or out of?
In custody. I
Okay,
guess I'm wondering.
so then counsel, I think procedurally, maybe file a motion to move up the sentencing date. I will state that